Please be seated. Good afternoon. When we took the luncheon adjournment suspension, the Honorable Attorney General was about to exercise his right of reply. Honorable Attorney General.
Thank you, Mr. Speaker. And I'm confident in saying I think I have a bit more friend in the chamber, given that I did not stand between colleagues and lunch. So I'm looking for more support. I'm expecting more support. Mr. Speaker, thank you very much. Let me begin by thanking honorable members for their support thus far on this bill, and in particular those who spoke, Mr. Speaker. And of course, there's always the situation that there's a tacit support of those who have not spoken. Mr. Speaker, before I touch on some of the other issues, let me just briefly, with your leave, deal with one issue. I think we have been, some of us have been inundated with correspondence from a particular passionate member of the public complaining about everything about this bill, the process, whether it's constitutional and all of that. And Mr. Speaker, I want to laud him for his interest in these matters. Of course, he pays attention, and so he's quite passionate about it. But said same guy, Mr. Speaker. Yeah, that guy. And so, Mr. Speaker, the gentleman, he is, I suppose, public-spirited individual concerned about whether the bill and the process is human rights compliant, including, I think, the issue of the minimum mandatory sentence. Mr. Speaker, if, for what it's worth, I'd like to just put his mind at ease by saying that the issue of whether you can have a mandatory minimum sentence is settled law. Cases have been, number of cases have been to court all the way to the Privy Council, and it is settled law. In fact, Mr. Speaker, when the concept was first introduced in the Cayman Islands in 2005, shortly thereafter, 2007, we had a challenge to the legislation then, in a case named Ebanks, Mr. Speaker. And it went all the way to the Court of Appeal. And it was said then by the court of Appeal, Mr. Speaker, I think it was a judgment from Court of Appeal Motley, J.A., who says, he quoted a case from the UK in which Lord Diplock had recognized the power of the legislature to provide, or prescribe rather, a range of punishment, including a minimum sentence. And he says, Mr. Speaker, in providing a minimum sentence of imprisonment for 10 years in the 2005 law, the legislature was acting entirely within its province to enact punishment for the commission of offenses of possession of unlawful firearm. The sentence was intended to apply to all persons who either pleaded guilty or were convicted by the jury after trial. It was not a sentence fixed by legislature for the appellant. And so the appeal was dismissed, Mr. Speaker. And before he did that, he went through a litany of cases where it was customary for parliaments to enact minimum sentence. And this, Mr. Speaker, as I say, was a direct challenge to the 10-year minimum sentence which we have now in the current legislation. Albeit we didn't have the Bill of Rights at the time, Mr. Speaker, but the European Convention on Human Rights was extended to the Cayman Islands. And Mr. Speaker, in more recent times, there's a matter from Jamaica that went to the Privy Council, again challenging the issue of minimum mandatory sentence. And this is even more startling, Mr. Speaker, because this was a 16-year-old youngster who was sentenced to 15 years for an offense of wounding with intent with the use of a firearm. And he argued, and the lawyers rather, argued on his behalf that among other things, his age and so on, it was not in order, not compliant with the Human Rights Charter, to have a minimum sentence, in this case 15 years, to which he was sentenced as a 16-year-old. Well, he committed the offense when he was 16, but he was sentenced when he was 17. Sentenced to 15 years mandatory minimum. And he complained to, he went all the way to the Privy Council. And Mr. Speaker, the Privy Council ruled that there was nothing wrong with that. It was quite in order. The board is satisfied that the minimum sentence imposed in this case was not incompatible with the Charter of Rights. So, Speaker, the position is, I think the Privy Council said something which I thought was probably quite relevant. If I might with your leave, it's just a one line. Grave indulgence, Mr. Speaker. Mr. Speaker, yes, that's the line that is they mentioned, which I found quite instructive, was where the court observed. It says, as the background to this case makes clear, it is the use of guns that has damaged Jamaican society and consequently attracts a sentence with a bigger deterrent element. Mr. Speaker, that's what we're trying to avoid. It's exactly what we're trying to prevent here. A situation where the guns damage the society. That's what as legislators we are trying to prevent. And if we don't do so, Mr. Speaker, it is going to be to the detriment of all of us, not just those of us who are sitting in this chamber today. So it is quite in order. Nothing is wrong with being passionate about human rights. That is how it ought to be. And as I said, I laud the gentleman for his effort, his interest in all of this, in trying to bring to everybody's attention the fact that what is being done should be compliant. And he likes to use Section 19 of the Constitution. He knows that, I mean, if you show it to him blindfolded, he would recognize it, Mr. Speaker. That's how much he knows that. That whatever being done by public servants must be proportionate and reasonable and all of that. He knows that. But there's a greater imperative. There's a greater imperative. And even the Constitution recognizes that for national security reasons and other reasons, sometimes the state must put in place measures that will prevent greater harm and so on. So, Mr. Speaker, I hope if he's listening, he will be satisfied that what we're doing here is compliant, and he can be rest assured that we try to remain within the four corners of the Constitution. Mr. Speaker, thanks again to all honorable colleagues, as I said earlier, who spoke on the bill. And during their contribution, some questions were raised by members about the bill itself, and some which we'll seek to address, Mr. Speaker. In particular, Mr. Speaker, I think we agree with the observation by the honorable member from Bodden Town East. Is that Saunders? Bodden Town West. About whether or not the regiment should be one of those agents or entities that the firearm bill expressly excludes, Mr. Speaker, when they are using firearm in furtherance of their duty. It so happens, Mr. Speaker, that we were not advised about that initially, but having read the Firearms Law and having read the Defense Act, Mr. Speaker, it is clear that it would be helpful to expressly reference the regiment in Section 44, Mr. Speaker. That would help to underpin or complement, if you will, the provision in Section 5.2 of the Defense Act to make it quite clear that if they are allowed to use firearms with the authorization of the commandant and the governor, then their possession and use of it would be undergirded by legislation, Mr. Speaker, and so they would be exempt from the provisions of the Firearms Act. So thanks to the Honourable Member for pointing that out, Mr. Speaker. Mr. Speaker, on the issue of minimum sentence for child molester, again, that's a useful observation. Many of our colleagues or members here will remember that sometime in 2017 or 18, I think it was, one of the first sessions in the BRAC, we had put in place some legislative measures when we were dealing with grooming of children for sexual activities. We had amended the penal code to impose very strict deterrent sentences for grooming offences. And one of the things that the Parliament did at the time was also, Mr. Speaker, impose a minimum mandatory sentence for persons who were involved in grooming, and in particular those who were in a position of trust as it relates to these children, and would then groom them for sexual offences. So the legislation was amended, the penal code was amended to ensure that there was a minimum period of imprisonment that persons would serve if they were convicted for that particular grooming offence, Mr. Speaker, if they were in a position of trust. So the point I'm making there is that in keeping with the Honourable Member's observation, I think we ought to and will be taking a serious look, Mr. Speaker, to see if we could expand on a range of offences as it relates to child molestation. That should also attract a minimum mandatory penalty of imprisonment for persons convicted thereon, Mr. Speaker. Mr. Speaker, the other thing he mentioned was spring gun, and I must confess that despite my best effort, I couldn't find anyone in this chamber who seemed to know what that is. I'm guided by you, Mr. Speaker, but I doubt you would have been exposed to one of those. A spring gun. I think we sort of conceptualized what it is, but it seemed to have been something that was used before our time by farmers. But I've spoken to the police about it, Mr. Speaker. Their position on this is that, as far as they're concerned, it is not something that would be of any interest to them at this stage in terms of seeking to regulate it, because given how it is probably constructed, it is not something that would cause them any concerns that it should fall within the definition of firearms, and therefore it needs to be regulated. What I can suggest, Mr. Speaker, is that we will, going forward, have a more serious dialogue about it and see whether it's something that needs to be taken on board. But we did have a look at it, Mr. Speaker. Not concerned for now. Mr. Speaker, one other member, yes. I agree, Mr. Speaker. There was some observation made by the crave indulgence. Some observation made about, yes. The point that was being made by one of the honorable members in this contribution was that the amendment to the Firearms Act is not a panacea to the antisocial behavior that we are experiencing in this society. It is really, if I understand him correctly, some of the behavior that is being displayed with the use of gun is really just a kind of a microcosm of a wider breakdown in our society. And therefore, a more holistic approach needs to be taken in terms of dealing with the root causes, Mr. Speaker. What is it that are causing especially our young people in our society to be displaying these sort of behaviors? It is a part of a wider problem, and therefore other measures should be looked at with a view to try and arrest, if you will, this sort of a decay, and to try and redirect our young people in a different direction so that they can live a life that is productive, Mr. Speaker, and law-abiding. And, Mr. Speaker, I agree with the honourable member. It is something that has occupied the minds of the government and others, Mr. Speaker. We are examining various measures. The government, the National Security Council, the National Security Coordination Board. We are looking at a number of the cabinet. We're looking at a number of initiatives, Mr. Speaker. One of them, as I said, is being spearheaded through the Deputy Governor's Office, the National Security Coordination Board. Spearheaded a number of issues, Mr. Speaker, that will take a more holistic approach to some of these issues, especially as it relates to our at-risk young offenders, with a view to see how we can assist them, Mr. Speaker, at a very early stage, early intervention. Now we have early intervention to prevent them from drifting, Mr. Speaker, in this direction. And so I agree with the honourable member that more needs to be done, and I can confirm for him that more is being done, Mr. Speaker. Mr. Speaker, one honourable member also mentioned the fact that because of the proliferation in firearm offences, members of the society are expressing fear in attending public functions, going into public places and calling up to wonder, and sometimes wondering aloud, whether it is safe to attend public events. And Mr. Speaker, that is unfortunate. And as I said earlier on at the top of my discussion, that's exactly what we're trying to avoid. We want to ensure that those who live and those who traverse these islands can be assured, Mr. Speaker, that the public safety is at the top of the list as it relates to government's priority. We're not trying to criminalize what the Sport Shooters Association trying to do. We're not trying to criminalize the gun club. We're not trying to criminalize persons who are hold of firearms license. We're not trying to criminalize what the farmers trying to do, Mr. Speaker. We're not trying to prevent them from shooting the goodies. What we're trying to do, Mr. Speaker, is make sure that the law, the legislation is up to date, is fit for purpose to deal with what I call bad actors, Mr. Speaker. Like any society, we have persons here who are up to no good. And so the government has an obligation to ensure that the firearms are not in the hands of the wrong persons. And if they are, and they are convicted, they will be treated in a way which acts as a deterrent to others, Mr. Speaker, those who are like-minded to get involved with unlawful use of firearms. That is all that the legislation is seeking to do. And therefore, if it is 35 years, or 20 years, or 10 years, persons need not be concerned about it unless, Mr. Speaker, they are planning to break the law. They should only be concerned about the length of the sentence and the severity of the sentence if they are planning to commit an offense involving firearm. Otherwise, why should they be? Mr. Speaker, the government is working assiduously to enhance public safety and, by extension, public confidence. The Commissioner of Police and his team are out and about, patrolling our streets, responding to calls, doing everything to keep our society safe. The ongoing gun amnesty, Mr. Speaker, is just but one recent initiative mentioned by the Honorable Deputy Leader of the Opposition. One of those initiatives that the government is pursuing, along with the RCIPS, is pursuing, Mr. Speaker. And I join with him in encouraging members urging members of the society who are in possession of unlicensed firearm to take advantage of the amnesty and turn in their unlicensed firearm. And also members of society, if they know of persons who are in possession of these firearms, to encourage them, Mr. Speaker, to hand these over to the police. One gun less on our street makes the place safer, Mr. Speaker. And so I hope that those who are involved will heed this clarion call. Mr. Speaker, I think this is a member from West Bay West, honorable member from West Bay West, the Honorable Permanent Secretary Bush. He inquired quite a lot, Mr. Speaker, what is being done about shoring up our borders to prevent or mitigate the proliferation of firearms into the Cayman Islands. Mr. Speaker, quite a reasonable question in the circumstances. The truth is, Mr. Speaker, the Cayman Islands does not manufacture firearms, and so they must be coming from somewhere. If you listen to the news, you follow what the police is saying, Mr. Speaker. Regrettably, these firearms are coming in through our borders, either by sea or airport or some other means, but they are here. And so, Mr. Speaker, they're coming in by boats, by canoes. This truth is, Mr. Speaker, that the government is working hard to try and shore up the borders. They have been using manual means, they have been using technology, they have been using all sorts of initiatives to try and prevent guns coming across. But, Mr. Speaker, we also need the support of those members of the society who have information that can assist with intercepting these firearms. And so, Mr. Speaker, the plan or the hope is that with these enhanced penalties, persons will be deterred from getting involved with importation of firearms. I mentioned, Mr. Speaker, in my earlier debate about some of these actors who are now buying the firearms in parts, Mr. Speaker. They buy them in circumstances where disassembled, and then bring in the parts, different parts at different times, and then once they get here, they assemble them, and Mr. Speaker, they have a firearm. It is not traceable because of the way it is put together and acquired. There are no serial numbers and so on. So it is very difficult for law enforcement to keep up with all of this. And so there's a need for enhanced vigilance, Mr. Speaker, sorry. There's a need for enhanced vigilance at the port to make sure that these behaviors are detected and dealt with in a timely manner, Mr. Speaker. Mr. Speaker, the effort in that regard is coordinated. There's a combined effort of the RCIPS, the Coast Guard, Customs and Border Control, and others. They have all been working very hard to prevent or mitigate, if you will, the flow of firearms across our borders. Mr. Speaker, it would also help me immensely if law-abiding citizens continue to assist the police, the Coast Guard, Customs and Border Control in doing so, Mr. Speaker, intercepting these firearms and so on. Mr. Speaker, I think I have touched on just about all the issues. There was one issue raised by the Honorable Deputy Leader of the Opposition during our discussion, which was not part of the presentation on the bill, and which we're still looking at as it relates to the issue of leaving firearms with others who are similar firearms license holder and the duration of that. We're hoping to have another look at it, and we'll be able to say more about that at the committee stage, so we see what happened there. But Mr. Speaker, with that, again, I would like to thank all honorable members for their contribution, both those who spoke and those who tacitly support the bill. I omitted in my earlier thank you to thank my assistant, Ms. Celia Middleton, who helped me with preparing for all this debate and so, and the drafters and the police officers, Ms. Mullins and Mr. Bryan and others for their support. And so, Mr. Speaker, with that, I would commend the Firearms Amendment Bill 2024 to honorable members of this House for a safe passage. I thank you, sir.
Thank you, Honorable Attorney General. The question is that a bill shortly entitled the Firearms Amendment Bill 2024 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Firearms Amendment Bill 2024 has been given a second reading and is accordingly set down for third reading. Madam Clerk.
Summary Jurisdiction Amendment Bill 2024.
The Summary Jurisdiction Amendment Bill 2024.
Mr. Speaker, I beg to move the second reading of the bill, the long title of which is A Bill for an Act to Amend the Summary Jurisdiction Act 2024 Revision to provide for the appointment of members of Parliament as Justices of the Peace Virtuti Officii, to restrict members of Parliament from exercising certain powers, functions, or duties of justices of the peace to avoid conflict with their role as members of Parliament and for incidental and connected purposes.
The bill shortly entitled the Summary Jurisdiction Amendment Bill 2024. The second reading thereof has been duly moved. Does the Honorable Deputy Governor wish to speak thereto?
Thank you, Mr. Speaker. I will. Mr. Speaker, I rise to present the Summary Jurisdiction Amendment Bill 2024. This relatively short bill, if passed, will significantly streamline existing appointment processes for members of Parliament to be appointed as justices of the peace, and thereby to further enhance access to JP services for persons across the Cayman Islands. The primary benefit of this bill, Mr. Speaker, is to augment the number of justices of the peace, JPs, who are available and willing to provide important services to the community, such as certifying documents, taking declarations, taking affidavits, and administering oaths. But for these voluntary services rendered by JPs, the associated cost of receiving such services might present significant hardship, financial hardship, from some members of our community. It is important to point out that unlike notaries public, who typically charge fees, justices of the peace provide such services free of charge. In addition to financial consideration, the bill enhances accessibility as well, as accessing such services commercially typically requires persons to leave their own districts in order to present themselves at business locations in order to receive these services. It would be remiss of me, Mr. Speaker, not to acknowledge the work of our existing JPs. The Justice of the Peace Association is to be commended for the arrangements it makes to provide JP services each week at the Government Administration Building in Georgetown. This service is offered by a small but committed number of JPs during regular business hours, in addition to any arrangements they and other JPs may personally make to be accessible within the districts. However, we know, Mr. Speaker, that we have a growing population and the demand is always significant. Mr. Speaker, therefore, the provisions set out in the bill, through these provisions, members of our Parliament, while carrying out their normal services to their own constituencies, will also be able to offer JP services as well, so that they can enhance the accessibility of such services to all the people of these islands, wherever they may reside. As our elected leaders, members of Parliament are preeminently qualified and have long made ideal candidates to carry out the functions of justices of the peace. Their intimate knowledge of their constituencies is a distinct asset. The current framework governing the appointment of JPs involves a lengthy nomination and robust interview process in order to ensure persons that are fulfilling this role are properly vetted. But bearing in mind that the members of Parliament are already subject to very strict eligibility requirements that are set out, for one thing, in the highest law of our land, the Constitution, as well as the fact that their interview process involves the panel of none other than the public at large who select them. We can be assured of the fitness of such persons to serve their communities in this additional capacity. As such, applying our existing administrative processes to vet candidates emanating from this honorable House who are already sworn to serve the people of the Cayman Islands is rightly deemed to be most unnecessary. It is important to note, Mr. Speaker, that an alternative mechanism already exists within the Act, which, with minor amendments, can provide a more streamlined route for the appointment of MPs as justices of the peace. This mechanism currently permits the appointment of public office holders as JPs without the need for an application and interview process based on the office that they already hold. This streamlined route allows for appointments to be made by virtue of the office that is held and is set out in Section 7(3) of the current Summary Jurisdiction Act. Utilizing the provisions set out in this bill will enable MPs to be swiftly appointed as justices of the peace upon their election if they are not already so appointed. The provisions of this bill will prevent unnecessary delay and duplication of administrative efforts. Mr. Speaker, the first part of Clause 2 of the bill will achieve this efficiency by inserting a new Section 7, subsection 3, subsection A to the Act, allowing the governor to appoint an MP by virtue of the office he or she holds. Clause 2 also goes further and seeks to recognize the unique role of MPs and seeks therefore to protect them and ensure the separation of powers among the three branches of government. The bill ensures that the adoption of a streamlined approach also respects the principle of separation of powers and offers clear protection for MPs from being put into a difficult position. To provide context, Mr. Speaker, it is important to note that JPs may perform other functions under the law, which may not be appropriate for sitting MPs to undertake. JPs may, for example, be requested to preside over a criminal or civil case as part of a panel pursuant to Section 12 of the Summary Jurisdiction Act, to sit on a police disciplinary panel pursuant to Section 101, subsection 4 of the Police Act, to permit cash seized on suspicion of being drug money to be released pursuant to Section 26 of the Misuse of Drugs Act, and to witness the destruction of election documents pursuant to Section 9, subsection 1 of the Elections Act, to name but a few examples of possible conflicts. Some of these functions give rise to potential issues relating to the principles of the separation of powers. This principle requires that the functions of the three branches of government to be clearly divided. Keen consideration has been given to prevent any overlap of these roles and, equally importantly, the perception of such, should these result in a real or perceived conflict of interest. In most cases, it will be obvious to an MP, as it is for other persons who serve as JPs, when their impartiality may be called into question if they undertake certain types of JP function. In such conflicts, like other serving JPs, they may and will decline to exercise those functions. However, in some cases, an MP may be unaware of all the facts surrounding the matter in which they are dealing as JPs, and their work could later be called into question. To avoid these scenarios, some countries have taken a very restrictive approach to protect against the risk by prohibiting elected leaders from acting as JPs. This is the case in Northern Ireland, where such appointments are only possible with the consent of the Lord Chancellor. We have never had such a broad prohibition in the Cayman Islands, and for very good reason. We do not believe that this is necessary. Other countries are protected against this risk by placing conditions on the conduct of certain functions. For example, by prohibiting MPs from acting as judges within their own local constituency, as is the case in England and Wales. Geographical restrictions are not practical within the Cayman Islands, Mr. Speaker, due to the relatively small size of our jurisdiction, coupled with the fact that courts and tribunals are located only in Georgetown, save for the sittings of the Summary Court in Cayman Brac. It is believed within our local context that an equally effective way of ensuring that MPs may provide JP services with clear safeguards is to provide for MPs to be appointed ex officio and for the duration of the time that they hold political office, to limit the functions which have the potential to give rise to such conflicts. I say have the potential to give rise to such conflicts because, Mr. Speaker, I note that in practical terms, persons serving as JPs have been quite judicious to avoid such conflicts. However, additional safeguards which have been provided include limiting functions which involve the exercise of judicial or quasi-judicial functions, or carry a risk of perceived impropriety due to their very nature. To this end, Mr. Speaker, Clause 2 of the bill inserts a new Section 3, subsection B to the Act, ensuring that such MPs will not be called upon to fulfill such functions. The bill is even-handed on the aspect of removal from the role of justices of the peace. Clause 3 of the bill ensures that MPs who are appointed under this new procedure are treated in the same manner as existing JPs when it comes to the process for the potential removal from the role. Mr. Speaker, Clause 4 of the bill provides a mechanism for MPs to retain their designation as JPs whenever he or she returns to private life and ceases to be an MP. Additionally, that former MP who becomes a JP by virtue of the position that they held will, under this bill thereafter, be permitted to exercise the full array of JP functions in their private capacity. Finally, Mr. Speaker, Clause 5 of the bill provides that these new provisions do not affect the validity of any historical work undertaken by a JP before the commencement date. In this way, Mr. Speaker, the bill looks forward and not retrospectively. The bill also contains certain transitional provisions. Justices of the peace have not for some time been routinely deployed to serve on panels in our courts or tribunals, although we know that there has been discussion about this in more recent times. Whilst we do not anticipate that there will be many, if indeed any, ongoing court cases or tribunals involving an MP serving on a panel, Clause 6 of the bill provides for such ongoing proceedings to be restarted if any party seeks a new panel in light of the new provisions coming into force. Again, this is deemed to be most unlikely, but has been added for good measure. The role of the JP is a significant one, and it comes with its own burdens and responsibilities. I should highlight the existing legal protections afforded to JPs. Under Section 40 of the existing Summary Jurisdiction Act, all JPs are protected from liability for their actions as JPs, provided these actions were all taken in good faith. This protection under Section 40 will automatically extend to MPs appointed as JPs under the new procedures in equal ways as they apply to existing JPs. There is as well an existing training requirement for JPs under Section 43, subsection A of the existing Summary Jurisdiction Act and the Justice of the Peace Regulations 2015. All JPs are required to undergo training and to observe a code of conduct. These requirements extend to all JPs, including those who are appointed by virtue of the position that they hold. In conclusion, while this is a relatively short bill, Mr. Speaker, it is hoped that it will improve the lives of numerous members of our community who need swift and convenient access to free JP services from persons who are most familiar to them and are most accessible wherever they live in these islands. This bill will also, for the avoidance of doubt, clearly signal that our members of Parliament are preeminently qualified and already sought out by residents within our districts to lend assistance. This bill will remove any procedural processes which may have unintentionally impeded their ability to render such assistance as duly appointed justices of the peace. It's therefore, Mr. Speaker, that I commend this bill to this honorable House. Thank you, Mr. Speaker.
Thank you, Honorable Acting Deputy Governor. The bill has been duly presented. Does any other member wish to speak? The Honorable Leader of the Opposition.
Thank you, Mr. Speaker. And thanks also to the Acting Deputy Governor for her able presentation of the bill. Mr. Speaker, just a few short observations. I think a bill such as this is long coming. And I'm really delighted here today that we are seeing it come to fruition. And I do believe that every member in this House will welcome this, or welcomes this change, and this ability and appointment of themselves to be appointed as justices of the peace. I know we've had a situation where at least one of our members was entitled to be appointed, but had yet to be done so, and this is going to take care of it for us. So, Mr. Speaker, I appreciate the very short and skillful way in which this has all been crafted and to put in the necessary safeguards in limiting the activities of a JP who is a member of Parliament and limiting the roles that they can undertake. And I think that goes a long way towards enhancing the, what's the word I'm looking for? The credibility, I think, of the office of a Justice of the Peace. For myself, I've been a JP for more than 20 years, and I think this really will go a long way to enhancing the respect and I say the respect that justices of the peace deserve in the role that they undertake, because the Deputy Governor talked briefly about, you know, the great role that we do fulfill in our community. And by and large, justices of the peace are well respected and in many times revered in this country for the time that they give and the work that they perform. And so, Mr. Speaker, if there's any doubt in anyone's mind with regard to our support here on the opposition, I say so unequivocally. We are happy to support the legislation and look forward to supporting it when we take the vote. So thank you with those few comments, Mr. Speaker.
Thank you, Honourable Leader of the Opposition. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If not, then I'll invite the Honourable Acting Deputy Governor to exercise her right of reply.
Thank you, Mr. Speaker, and I would also just like to express my sincere thanks to the Honourable Leader of the Opposition for his explicit support for this bill. And indeed, I expect to all honourable members of this House for your implicit support of this bill. The Honourable Leader of the Opposition is correct. This has been long coming. A very thoughtful approach has been taken to crafting this bill in a way that we hope will provide permanent relief to our existing and any future members of this honourable House, allowing them to be easily appointed automatically by virtue of the offices that they hold as Justices of the Peace. So we are very, very grateful to be able to finally bring this relief. And again, my sincere thanks to the Honourable Leader of the Opposition and honourable members of this House for their support.
Thank you, Honourable Deputy Governor. The question is that a bill shortly entitled the Summary Jurisdiction Amendment Bill 2024 be given a second reading. Those in favor, please say aye.
Aye. Aye.
Those against, no. The ayes have it. Accordingly, the Summary Jurisdiction Amendment Bill 2024 has been given a second reading and is set down for a third reading. Madam Clerk.
Perpetuities Amendment Bill 2024.
The Perpetuities Amendment Bill 2024, I recognize the Honourable Acting Premier.
Thank you. Mr. Speaker, I beg to move the second reading of a bill entitled Perpetuities Amendment Bill 2024.
The bill has been duly moved. Does the Honourable Acting Premier wish to speak thereto?
Yes, Mr. Speaker.
Please proceed.
Mr. Speaker, I rise to present the bill on behalf of the government. It's a bill that seeks to amend the Perpetuities Act 1999 revision, which I'll refer to hereafter as the Principal Act, to provide for the disapplication of the rule against perpetuities, to correct typographical errors, and for incidental and connected purposes. Mr. Speaker, to briefly discuss the reasons for the bill, the rule against perpetuities, which I'll refer to for short as the rule, was formulated to address certain fundamental considerations regarding trust, such as the devolution of property for estates. For example, the rule prevents a property owner from controlling the assets the property owner places in trust indefinitely after death. The rule was for the first time applied by the courts of England in 1681 and holds that private trusts may not be created for unlimited lengths of time. Originally, Mr. Speaker, I believe that the perpetuities period was for the length of a life or lives in being plus 21 years. The rule has now been modified by statute in a number of countries, including the United Kingdom, and also here at home in these islands and many other countries. In Cayman, the Principal Act currently establishes a statutory perpetuity period of 150 years, which can neither be extended or shortened. Mr. Speaker, industry groups through our Financial Services Legislative Committee recommended that the Act be revised to disapply the rule for all future trusts and all existing trusts retroactively, but only with an application to the Grand Court. This recommendation for a commercial enhancement was made to the ministry, and based on the findings that indicated that several comparative financial services centers have removed the perpetuities provision from their respective legislation. Mr. Speaker, as part of its legislative development process, the ministry assessed the effect this proposed change may have on the success of the island as a globally respected financial services center, what the impact may or may not be on our strong anti-money laundering framework, and the international landscape of trust business. Mr. Speaker, the ministry policy team concluded that this proposed change would be advantageous, given the potential attraction of even greater sound global trust business. Furthermore, the ministry policy team found that other jurisdictions have implemented the change without negative impact on their international anti-money laundering ratings. However, Mr. Speaker, if we need to adopt additional safeguards in due course, if standards change, in order to maintain our favorable ratings, we shall do so. Accordingly, Mr. Speaker, the ministry drafted a proposed amendment bill to the Principal Act and held industry consultation in January of this year. Pursuant to feedback received during the consultation, material changes were made to the bill to align the provisions with the feedback received. The ministry held a second round of consultation in May 2024, which included the Monetary Authority, and then finalized the bill based on comments received during that round of consultation. Mr. Speaker, that then shows that the bill has been drafted in partnership with the primary regulator and industry participants. We understand that the trust and estate sector, as well as family offices, are now attracted to financial services centers that offer trust investment vehicles with an optional perpetuity period. It's therefore important that these islands keep pace and continue to offer cutting-edge products. We believe this amendment will serve to ensure Cayman remains a prime destination for sound trust business. To summarize, Mr. Speaker, some of the more substantive clauses, The first substantive proposed amendment in relation to the bill is, of course, the disapplication of the rule to future trust. The bill inserts a new Section 19, which states that any trust created after the commencement of this bill may choose to specify in the instrument creating the trust whether the rule applies. This makes the application of the rule optional when a trust is created, granting a settlor more flexibility in determining the duration of the trust. Section 19 also specifies that a trust may not disapply the rule if it has an interest in land in these islands. This is to ensure that local real estate does not get unintentionally tied indefinitely into a trust. A new Section 18 provides some definitions and defines an interest in land to exclude income from land in these islands and the proceeds of sale of lands in these islands. Mr. Speaker, the bill adds a new Section 20, which allows for a retroactive disapplication of the rule to existing trusts by application to the Grand Court. The provision further directs the Grand Court to ensure the disapplication of the rule would not be to the detriment of the beneficiaries of the trust. Again, the provision also ensures that the trust cannot hold interest in land in these islands. Mr. Speaker, the bill also introduces a new Section 21, which specifies that a foreign trust which is not subject to the rule may, subject to Section 89 of the Trust Act, change the applicable law to the law of these islands without the need to apply to the Grand Court for disapplication of the rule. Mr. Speaker, to provide this House with a brief overview of the bill's clauses in order, the bill has been arranged in 6 clauses. Clause 1 provides the short title of the legislation. Clause 2 provides for the amendment of the Principal Act by inserting proposed parts headings in the Principal Act. Clause 3 amends Section 4 of the Principal Act to correct the typographical error. Mr. Speaker, Clause 4 amends Section 14 of the Principal Act to clarify that references to the court in that section are to the Grand Court. Clause 5 amends Section 15 of the Principal Act to update the section heading to reflect properly the contents of that section. Clause also amends Section 15 to clarify that references to the court in that section are indeed to the Grand Court. Clause 6 provides for the amendment of the Principal Act by inserting a new Part 3, which provides for the disapplication of the rule against perpetuities. And Mr. Speaker, the proposed new Part 3 contains proposed new sections 18 to 21. The proposed new Section 18 provides definition for the words enforcer and settlor. It also provides for the interpretation of the reference to land in the islands or an interest in land in the islands. The proposed new Section 19 provides that where a disposition is made by an instrument which comes into effect on or after the commencement of this legislation, and the disposition does not relate to a trust which holds land in the islands or an interest in land in the islands. The instrument by which the disposition is made may by its terms provide that the rule against perpetuities does not apply to that disposition. Mr. Speaker, proposed new Section 20 provides, among other things, that trustees, settlors, and enforcers of certain trusts may apply to the Grand Court to disapply the rule against perpetuities. And the proposed new Section 21 provides that where a trust is of unlimited duration and to which the rule against perpetuities does not apply under its governing law, changes the governing law of the trust to the law of these islands, a disposition made in respect of the trust shall not be subject to the rule against perpetuities under the law of these islands. Mr. Speaker, as you can see, it's a relatively short amendment bill, and therefore that concludes my presentation on the bill. In closing, I wish to thank the ministry policy team for moving on this matter expeditiously and working collaboratively with industry practitioners, the Monetary Authority, who I'd also like to thank, and of course, the Financial Services Legislative Committee, chaired by Charles Jennings and ably aided by Al Robertson. And of course, last but certainly not least, the Legislative Drafting Department for their efforts with respect to the design and preparation of the bill. Mr. Speaker, I therefore commend the Perpetuities Amendment Bill 2024 to this Honorable House for its second reading.
Thank you, Honorable Acting Deputy, Honorable Acting Premier. The bill has been duly presented. Does any member wish to speak? The Honorable Leader of the Opposition.
Thank you, Mr. Speaker. Mr. Speaker, thank you for the opportunity to speak just briefly to the bill at hand. And here, Mr. Speaker, just to signal our support again for this piece of legislation. Legislation has been through such wide consultation, not just once, but you indicated twice with industry, regulators, and all those involved in the trust industry. Clearly, this amendment is intended to benefit the financial services industry, and we therefore fully support it. Thank you, Mr. Speaker.
Thank you, Honorable Leader. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If no other member wishes to speak, I'll invite the Honorable Acting Premier to exercise his right of reply.
Thank you, Mr. Speaker. Very briefly, to thank the Leader of the Opposition for express support and all other members for their tacit support, and to thank my colleagues in caucus and cabinet for seeing the wisdom of adding another feather in the cap of our financial services industry. Thank you, Mr. Speaker.
The question is that a bill shortly entitled the Perpetuities Amendment Bill 2024 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, the Perpetuities Amendment Bill 2024 has been given a second reading and is set down for third reading. On the clock.
Pharmacy Bill 2024.
The Pharmacy Bill 2024. I recognize the Honorable Minister for Health and Wellness.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled the Pharmacy Bill 2024.
The bill has been duly moved. Does the Honorable Minister wish to speak thereto?
Yes, sir. Thank you. Yes, Mr. Speaker.
Please proceed.
Mr. Speaker, I rise to present the bill on behalf of the government. This bill repeals and replaces the Pharmacy Act 1979 and the Pharmacy Act 1991 with a new regulatory regime for the importation, manufacture, wholesale, dispensing, and prescribing of medicines and for all incidental and connected purposes. This bill, Mr. Speaker, is divided into 6 parts. Part 1 of the bill deals with primarily matters. Part 2 of the bill provides the various licenses that will allow a person to import, manufacture, and sell wholesale medicine. This part also provides for the authorization that render a medicine approved for the purpose of the legislation. Part 3 of the bill contains provisions regulating how medicines are dealt with. Part 4 contains provisions relating to enforcement of the legislation. Part 5 contains miscellaneous provisions, and Part 6 of the bill provides for repeals. 45 years after it was enacted, the Pharmacy Bill of 1979 remains the piece of legislation in force guiding pharmacy practice in the Cayman Islands. Now, while the Pharmacy Act of 1991 was gazetted with the intentions of replacing the 1979 Act, the corresponding regulations were never completed, and as such, the 1991 Pharmacy Act was never enacted. Mr. Speaker, to say that this piece of legislation is no longer fit for purpose is an understatement. In every aspect, our world today looks far different than it did in 1979. Let me just put it into context. Can we recall what Georgetown looked like in 1979? There were no TVs, no computers. What was cell phone or Facebook, Instagram, Snapchat? Anybody remember Patterson's, Comart, By-Right, even 19 Hole? Anybody remember 19 Hole restaurant? Exactly. I can recall Georgetown where the Catholic Church, red and white, right where Elizabethan Square is right now. And remember that little hog plum tree right there in the front of Miss Louise Llewellyn where Jose's gas station used to be? Yep. That's how far back we can go, and where we're coming from. Might I say, even Shirley Shop, Farmer's Bright Spot. Yes, I'm going back, but I hope you get the context of where we're coming from, and definitely Miss Maud is. And access to medication and modernizing our legislation is no different, and we have failed. But I am happy to be here today. And access to medications and pharmacy practices itself has certainly evolved in the past 4.5 decades. To be exact, I was only 5 years in 1979. I just told my age. It is important to note, Mr. Speaker, that back in November 2021, the Office of the Auditor General performed an audit on the Health Services Authority's outpatient pharmacy services to evaluate its efficiencies and effectiveness. One of the audit's recommendations directed to my ministry, Mr. Speaker, was that we had to prioritize the development of a new national strategy for health that provides overarching direction for pharmacy services and the use of medicines. Mr. Speaker, I am proud to inform this honorable House that the strategy is currently underway. The consultation period for the National Health Strategy was held and concluded on May 31st, 2024. My ministry team, in consultation with the Pan American Health Organization, are working towards a draft plan that will appeal to the current health needs of the nation. Another recommendation from the OAG was to update the current Pharmacy Act, 1979. Thus, it has been my ministry's primary objective to provide an all-encompassing piece of legislation that speaks to the current issues of regulations, handling, storage, distribution, and importation of pharmaceuticals. As such, the need to reform the current legislation and, by default, pharmacy practice policies is strongly supported by the pharmacy profession and the greater healthcare community. The aim of the Pharmacy Bill 2024 is to close unintended gaps and prevent conflicting provisions that currently exists. This will provide a legal framework for the proper regulation of the pharmacy profession and the safety of the residents of the Cayman Islands. Following a 60-day public consultation period that was held between September 29th and November 30th of 2023, the ministry's team compiled a list of proposed amendments which reflected international best practices, as well as the feedback from key stakeholders and other members of the public. Now, after receiving, Mr. Speaker, approval from my cabinet to proceed with the amendments, the ministry collaborated with the Portfolio of Legal Affairs to produce a competent and relevant final version of the Pharmacy Bill 2024 that is before us today. The list of recommendations made, Mr. Speaker, facilitates the proper wording and fluidity of specific clause within the proposed bill to prevent confusion and misinterpretation. I must wholeheartedly thank the public for their diligent review of the bill and their ability to provide such substantial recommendations to the bill, which has fortified it even more. Mr. Speaker, I will now provide a detailed overview on the clauses contained in the final version of the Pharmacy Bill 2024. The preliminary part of the bill, Part 1, sets Clause 1 and 2, which consist of the short title and commencement of the legislation, as well as the interpretation of various key terms to be found in the bill. For example, Clause 2 of the bill reflects the definition of the word medicine, which will now include animals. Thus, Clause 2A1 of the bill will read, "A substance or combination of substances presented as having properties of preventing or treating disease in human beings and/or animals." We all know that we have those pets that sometimes fall ill themselves and requires medication that is also good enough for to be consumed by humans. As we evolve, why not include our pets? The inclusion of the word animals was deliberate, Mr. Speaker, like I alluded to, and reflects the feedback presented by local stakeholders to ensure that the bill accommodates the duties of veterinary surgeons. Veterinary surgeons need to also be able to dispense medications, and if they are not included in the bill, this will prevent the practice of veterinary medicine here in the Cayman Islands. Clause 2 also includes a wider definition of prescriber, which will allow the flexibility of practitioners other than doctors, dentists, and veterinary surgeons to prescribe medicines within their scope of practice, thus reflecting the growing importance internationally of nurse practitioners and pharmacists, amongst others, as clinical practitioners. I will now proceed with presenting the substantive components of this bill. Mr. Speaker, my ministry is cognizant that the restriction on importation of pharmaceuticals is an important public safety measure to ensure that only medicines of appropriate quality and traceability are imported and made available to patients in the Cayman Islands. Thus, Clause 3 in Part 2 of the Pharmacy Bill sets out the conditions under which persons are authorized to import medicines to the islands. It restricts the importations of approved medicines to people holding appropriate licenses and exempts those who wish to import medicines for personal administration. Mr. Speaker, these parameters are designed to ensure that we are not criminalizing visitors to our islands, nor people who receive treatment off island and return with medicines to complete their treatment. It is worth noting to this Honourable House that the wording of the bill has been specifically drafted to balance concerns about personal importation, where the underlying reason may be for unregulated commercial sale and avoidance of payment of duties, with the need to avoid penalizing visitors or individuals who, out of necessity, need to obtain medicines from outside of the Cayman Islands. This, Mr. Speaker, was not a theoretical exercise, but one that was intentionally made following representations made by other members of this Honourable House to me where such instances have actually occurred. You will remember, Mr. Speaker, that the Pharmacy Act 1979 did not address manufacturing of medicines in the Cayman Islands. Up until this point, our license conditions have allowed the wholesale importation, supply, and dispensing of medicines. However, the bill being tabled today will modernize our approach by also providing for manufacturing of medicines in the Cayman Islands, the condition for which are set out in clauses 4 and 5. This, Mr. Speaker, will be a first for us. Mr. Speaker, in terms of license applications, clause 7 to 11 of the bill provide for these to be decided by the Pharmacy Council, using the criteria of fit and proper persons meeting the conditions defined within the Act for the provision of a safe and secure service. A small caveat to note also, Mr. Speaker, is that whilst licenses are ordinarily issued for a 3-year period, they may be suspended or revoked as necessary by the Council. Mr. Speaker, I am sure the House would agree that the safety and efficacy of medicines are paramount to the health and well-being of every single person living here in our islands. As such, clauses 12 to 14 of the bill now provide for the Council to set out what medicines they consider to be safe and effective for use here in the Cayman Islands. Mr. Speaker, safeguards are also built into the bill to allow the Pharmacy Council, in exceptional circumstances, to authorize the usage of medicine that would otherwise be unapproved. The exception may be either for a class of patients or an individual specific patient. Mr. Speaker, the bill also provides Cabinet with the power for emergency authorization, building on the lessons of COVID-19, so that we can rapidly license medicines that may be required countrywide. Part 3 of the bill, Mr. Speaker, addresses the topic of dealing with medicines. Clauses 15 and 16 of the bill provide controls of non-approved medicines and create an offense in the instance of importation and the use of non-approved medicines. The bill further stipulates that medicine should not be supplied by a retailer unless under the supervision of a pharmacist and within the confines of a certified pharmacy or after obtaining a dispensing license. Clause 16 of the bill does provide an exception for specific over-the-counter medicines and natural supplements to be supplied in retail stores, such as supermarkets and gas stations, without the store owners needing to obtain a wholesale license. Furthermore, Mr. Speaker, while it is permissible to compound a medicine provided that such is done by a skilled and qualified person, it is otherwise illegal to alter a medicine according to clauses 17 and 18. For clarity to the House, Mr. Speaker, compounding medicines refers to the process of creating personalized medications for patients by combining, mixing, or altering ingredients to tailor medication to an individual's specific needs. This practice is used, for example, when standard medications are not available or a patient is unable to tolerate a commercially available medication. Mr. Speaker, clauses 19 and 20 of the bill also make it a requirement that medicines should be clearly prescribed and not described in any misleading way in terms of their quality or effectiveness. The medicine should be accompanied by an appropriate information. In particular, all medicines must be supplied with a patient information leaflet in English, although exemptions may be made in unusual circumstances by permission of the Chief Medical Officer. In terms of vending machines, Mr. Speaker, Clause 21 of the bill makes it illegal for medicines to be dispensed from vending machines. However, this does not include medicines that would ordinarily be available through general sales, such as simple painkillers and acids. Furthermore, Mr. Speaker, Clauses 22 also stipulates that it is illegal for medicines to be dispensed via the internet or mail order pharmacies. The bill sets out the privileges of a wholesale pharmacy license or manufacturing license in Clause 23. Clause 24 allows ship physicians to prescribe a limited supply of medicines to ensure that tourists on cruise ships can receive any urgently required medicines. Mr. Speaker, we are aware that there have been issues with unauthorizing altering of prescriptions. Thus, Clause 25 of the bill now creates a specific offense of altering a prescription. My ministry is also actively investigating more secure and effective ways of prescribing medicines, potentially using a national electronic prescribing system. Such a system, Mr. Speaker, would revolutionize our approach to prescribing medicines, as it would prevent duplication in prescribing. It would automatically identify dangerous interactions between prescribed medicines, while offering safeguards where allergies and other contraindications to medicines may be present, as well as intercepting any potential fraudulent dealings with medicines. Such a secure and confidential system will ensure that all certified pharmacies in the Cayman Islands will have the ability to monitor and record the prescribing record for a patient. In this respect, public and private pharmacies will have interconnectedness that is required to provide quality health care for a coordinated approach. Mr. Speaker, once implemented, we envision that a national electronic prescribing system would become the sole method for prescribing within the Cayman Islands. Mr. Speaker, Clause 26 of the bill sets out rules on dispensing prescription-only medicines and includes a provision that pharmacists may dispense a supply of prescription-only medicines without a prescription in emergency situations after meeting specific criteria. Recognizing that substantial cost savings are available through the use of high-quality generic medicines, Mr. Speaker, Clause 27 of the bill also authorized dispensers to dispense bioequivalent generic medicines, provided the prescription permits substitutions to be made, as some substitutions may be prohibited by the regulations. This measure will help make medicines more affordable to patients, Mr. Speaker. Preliminary results from the STEPS 2023 National Survey highlights some worrying discrepancies when it comes to the number of persons who have been diagnosed with a prescribed medication for diabetes, high blood pressure, and raised cholesterol, and those who are actually taking the said medication. We know, Mr. Speaker, that the cost of medication impacts patients' compliance, so this measure within this bill will help to mitigate this barrier to access. You will remember, Mr. Speaker, that at the outset of this presentation, I referred to the bill's wider definition of prescriber, and it provides that a prescriber is a person acting within the scope of practice and complying with the requirements prescribed by the regulations. In terms of administering a prescription-only medication, Mr. Speaker, a person administrating a prescription would normally only be the prescriber of the medicine, acting in accordance with the written directions of the prescriber of the medicine. However, Clause 29 of the bill now includes a registered practitioner acting within their scope of practice, therefore allowing for the supply of medicines in smaller communities and to define groups such as women seeking family planning from midwifery services. This is important, Mr. Speaker, because it is our duty to ensure that healthcare services are inclusive and accessible to everyone, whether they are located in Grand Cayman or on the sister islands. Thus, it should be noted by the House that Clause 29 of the bill will also ensure that appropriate healthcare professionals may administer medicines while acting within the scope of practice or following the directions of a prescriber. This, Mr. Speaker, will enable healthcare accessibility to smaller communities such as Little Cayman. Mr. Speaker, Clause 30 refers to the possession of prescription-only medicines and limits this to appropriate professionals and patients and persons acting on behalf of patients. As such, persons who are unable to retrieve their medications for whatever reasons may allow a company, family member, or friend to collect on their behalf. Clause 31, Mr. Speaker, is a residual power retained from the Pharmacy Act of 1979 to allow control on the supply and labeling of poisons. Moving on to Part 4 of the bill, Mr. Speaker, which comprises clauses 32 to 36. This part sets out the means of enforcing the Act by appointment of inspectors to the Council. It gives such inspectors the appropriate powers to enter, inspect, search, and take samples of anything found which they suspect to be a medicine and which they reasonably believe to be linked to the commission or intent to commit an offense. The bill also provides restriction on the power of entry such that inspections are carried out after notice have been given to the owner of the said property, preferably in writing. Mr. Speaker, this particularly applies to protection given to places of residence in order for the inspector to only enter on the explicit permission of the owner or if authorized under a magistrate's warrant. Mr. Speaker, I plea for a little more of your attention and that this Honourable House, as I present the last part of the bill, that being Part 5. Part 5 of the bill, Mr. Speaker, addresses various miscellaneous elements. Importantly, it protects from liability and indemnifies the registrar, inspectors, members of the Pharmacy Council, and the Chief Medical Officer from acts done in good faith within the exercise of the power and functions of the Act. Mr. Speaker, it also binds these individuals to not disclose information intentionally or recklessly unless for the explicit purpose connected with the Act. Part 5 also provides for appeals against the decision of the Council and allows the Cabinet to make regulations on the advice of the Council, the Chief Medical Officer, or the Chief Nursing Officer on aspects relating to regulations, prescribing, and safe use of medicines controlled under this Act. A few other changes reflected in the bill are as follows. The definition of scope of practice will now reflect the same definition as in the Health Practice Act 2001 revision. On March 20th, 2024, the Pharmacy Council produced the scope of practice for pharmacists and pharmacy technicians to ensure proper regulation and professional compliance of registered practitioners in the field of pharmacy. All licenses, importing, manufacturing, wholesaling, and dispensing of medicines may be renewed, and the Chief Medical Officer and Director of Agriculture have been included, as they may import approved medicines. Mr. Speaker, this Act repeals all former legislation, explicitly the Pharmacy Act of 1979 and the Pharmacy Act of 1991. In closing, Mr. Speaker, the Pharmacy Act of 1979 cannot withstand the current needs associated with the inner workings of the pharmacy profession, nor does it provide the necessary assurance for proper safety protocols for the people of these Cayman Islands. The Pharmacy Bill of 2024 will not only promote and facilitate the safety and efficacy within the pharmacy provision, but it will also positively impact the public's perception and trust in our local healthcare system. This bill is an overarching piece of legislation capable of answering the needs of a modern healthcare community, and the people of our islands deserve nothing less. Mr. Speaker, I would like to thank the members of the Legislative Drafting Unit and POLA, all consultees, and the staff of my ministry who have worked tirelessly and expeditiously to bring this over this golden, almost finish line. I look forward to the support of all members of this Honourable House in helping to strengthen Cayman's healthcare system by the passing of this important piece of legislation. And therefore, Mr. Speaker, I commend this bill entitled the Pharmacy Bill 2024 to this Honourable House in the second reading. Thank you.
Thank you, Madam Minister. The bill has been duly presented. Does any member wish to speak? The Honourable Leader of the Opposition.
Thank you again, Mr. Speaker, for the opportunity. Very quickly, just to signal our support for the bill as it is before us. Mr. Speaker, this is one bill that I have to say, too, has long been coming. And I congratulate the Minister and the Ministry for getting the bill before this Honourable Parliament. I was heartened to hear her say that they had consulted with industry on the bill, and that industry is supporting and supportive of the bill as it presently stands. I think that's just it truly is a key element of the success of any bill. And I have to say that accords with what we have seen since the bill was first exposed and released. Mr. Speaker, we've not received any feedback from industry with regard to the bill. And normally, if they have problems with it, Opposition is normally the first place they go to air their grievances and to seek support for hearing and further discussion. So that hasn't happened. So I'm heartened by the fact that it would appear that the industry is supportive of this bill, and look forward to supporting it at the appropriate time, Mr. Speaker. Thank you.
Thank you, Mr. Leader. We have now reached the moment of interruption. If we are to proceed, I will need to have a motion to suspend Standing Order 10-2 in order that business of the House may continue beyond the moment of interruption.
Thank you, Mr. Speaker. I hereby move for the suspension of Standing Order 10-2 so the business of this House can proceed beyond the hour of interruption.
Thank you. The question is that Standing Order 10-2 be suspended in order that the business of the House may continue beyond the moment of interruption. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, Standing Order 10-2 is suspended and the business of the House will now continue. In relation to Pharmacy Bill 2024, does any other member wish to speak? The Honourable Member from Bordentown West.
Thank you, Mr. Speaker. And Mr. Speaker, my contribution will actually be very brief. Firstly, I want to thank the government for bringing this long overdue bill. The minister referred that she was 5 years old when the last bill came in effect. Well, I was only 6 years old when it did, so I do understand where she's coming from. I only have two observations, or rather three observations, Mr. Speaker. And again, like I said at this point, and to borrow a lesson that you taught me my first term, never to let the perfect be the enemy of the good. So this is definitely a good place to start in moving this bill forward, because like I said, it's long overdue. My only observations, and this is maybe something that the legal drafting team can look at, because I don't think it's something mainly material, maybe more from my understanding, is just looking at some of the fines that they have in different sections. So to give an example to honorable members and persons listening, on page 14 that deals with importation of medicines, and it says a person may import and approve medicine as follows, and it sets a criteria. But then it goes on to say in section 2, a person who imports a medicine except as specified in this section commits an offense and is liable on conviction to a fine of $10,000 or to imprisonment for a term of 2 years or both. But then when you go to page 20 and you look at section 15, and it speaks about dealing with non-approved medicine, it basically says a person who contravenes subsection 1 commits an offense and is liable on conviction to a fine of $20,000 or to imprisonment for a term of 5 years or both. Well, looking at 3 and looking at 15, if you're doing something that is not an approved list, then it means it's technically not approved. So at a minimum, the sentences or the fine should be closely aligned. But again, it could be my misinterpretation of it, or I don't know what the drafters, but understand their intention. And then the other issue for me, Mr. Speaker, is just on the search and seizure going into residences. I noticed it mentioned specifically that getting a warrant by a magistrate. And I just want to make sure when we say magistrate, that we mean magistrate, and it's not a situation where someone runs to justice for the peace in the middle of the night. Because we have seen in this house, when these justices of the peace signs these warrants, the millions of dollars that it has cost the taxpayers of this country already. And I know of 2 cases off the bat. So when they say magistrate, I hope it actually means magistrate and not a justice of the peace. So I just want, maybe the AG can clarify that on the law or something. But outside of that, Mr. Speaker, I am very happy to see this bill being brought. I know there are a lot of enforcement part that deals in the regulations, which is done by cabinet, and is not something that will come to this honorable house. So I'll trust the government from that regard. But it seems that they was widely consulted, and as the honorable leader of opposition said, I too received no major objections from anyone in the public, and normally they would complain. So it seems like it's definitely a good step forward, and I definitely will be supporting this. Thank you, Mr. Speaker.
Thank you, honorable member. Does any other member wish to speak? Does any other member wish to speak? The honorable member from Newlands.
Thank you, Mr. Speaker. Mr. Speaker, I'll be brief. I rise to join other members who have spoken in relation to this bill to indicate my complete support for the bill. It is, as has been noted, a bill that is a long time coming to fully and properly regulate the manufacturing, the dispensation, and importation of medicines. This obviously has significant public health, safety, and health implications, so it is significantly important to the people of this country, Mr. Speaker. And I congratulate the Minister. I know a tremendous amount of effort has gone into this. I congratulate all the members of the Ministry in doing the work necessary, as has been indicated, to ensure that there's wide and full public consultation in respect of this. I know in the past there have been attempts and there was pushback. So to get this to this point without any significant responses in the negative from industry, I think is reflective of the good work that has been done in respect of getting this bill here. Thank you. Congratulations again to the Minister and the team, and thank you, Mr. Speaker.
Thank you, honorable member. Does any other member wish to speak? Does any other member wish to speak? The Honorable Acting Premier.
Thank you, Mr. Speaker. I'll be brief. It's really just on behalf of the government to thank the Honorable Minister for taking up the challenge of moving and dealing and evolving with evolving outdated legislation. It's not easy. I'm sure it took painstaking efforts with her staff in the ministry, legal drafting, consultation that would needed to have been done. I've been there myself, and I know it's a monumental task. So I applaud the minister, her team, all who supported, and the industry and the opposition for their support to evolve this outdated legislation. Thank you, Mr. Speaker.
Thank you, Honorable Acting Premier. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If no other member wishes to speak, I'll call on the Honorable Minister to exercise her right of reply.
Thank you, Mr. Speaker, and to say humble and honored is an understatement. Getting this piece of legislation to where it is today. And I must applaud again and give thanks publicly to those who have contributed to this piece of legislation. Those who haven't spoken, but I know I've received their tacit support. For all of the persons engaging this piece of legislation to make sure that we got it right at this juncture. The consultation period was even extended beyond what was normal. And I must say that we have demonstrated to be the ministry when it comes to being and taking up a data-driven approach, not just being lip service, but it has definitely proven, based on the level of public consultation, industry stakeholders, the involvement of the pharmacy councils, and external, making sure that we are engaged from an international standpoint, breaking down of silos, collaborating, etc. I'm just so happy for the buy-in from the community in definitely moving this outdated piece of legislation to now being here on this floor of Parliament on this day, presenting and being tabled the Pharmacy Bill 2024. Now, in regards to some of the issues that were brought up, those will be addressed, I'm quite sure, at the committee stage. If there's anything that will be there, and that language will be sorted out to allay any fears of any misinterpretation. And I am sure that the office of our legal drafting team will definitely make sure that that aligns with any issues or flaws that have been pointed out here. So, Mr. Speaker, I want to thank everyone, my colleagues, cabinet, the ministry team, and all of those persons who have made this possible for us to reach this milestone for the betterment of pharmacy and legislative governance here in the Cayman Islands. This is a huge step for us. Thank you.
Thank you, Honourable Minister. The question is that a bill shortly entitled Pharmacy Bill 2024 be given a second reading. Those in favour, please say aye.
Aye.
Those against, no. The ayes have it. Pharmacy Bill 2024 has been given a second reading and is set down for third reading. Madam Clerk.
Supplementary appropriation, January 23 to December 2023 Bill 2024.
Supplementary appropriation January 2023 to December 2023 Bill 2024. I recognize the Honourable Acting Premier and Acting Minister of Finance.
Thank you, Mr. Speaker. I beg to move the second reading of a bill shortly entitled the Supplementary Appropriation January 2023 to December 2023 Bill 2024.
The Supplementary Appropriation January 2023 to December 2023 Bill 2024 has been duly moved. Does the Honourable Acting Premier and Acting Minister of Finance wish to speak thereto?
Yes, Mr. Speaker.
Please proceed.
Mr. Speaker, the purpose of this bill is to seek the Parliament's approval for appropriation changes with respect to output groups, various other classifications of operating expenditure, equity investments, and executive assets in respect of the government's financial year that ended on 31 December 2023. Once an initial appropriation bill for a financial year has been approved by Parliament, the bill, upon its approval by Parliament, becomes the Appropriation Act for a particular financial year. Such an act establishes what is commonly referred to as the budget for a financial year. Mr. Speaker, there are three ways in which the budget amounts contained in an appropriation act can be changed during the course of a financial year. Firstly, Mr. Speaker, Section 11, subsection 5 of the Public Management and Finance Act allows the Cabinet to make such changes. Secondly, Section 12, subsection 2 of the Act allows Finance Committee to approve changes to an established appropriation act. And thirdly, Mr. Speaker, Section 25 of the Act permits Parliament to authorize changes to an already approved appropriation act. Mr. Speaker, this bill arises in respect of the government's use of these sections of the Act. Mr. Speaker, when a government utilizes the mentioned sections to make changes to figures contained in an appropriation act, the act requires that such changes be included in a supplementary appropriation bill, which must be presented to Parliament. Mr. Speaker, this explains the existence of the bill now before the House. It satisfies a legal requirement that changes to an already approved appropriation act must be placed in a single supplementary appropriation bill after a financial year has ended, and that bill must be presented to the Parliament for its scrutiny and potential approval. Mr. Speaker, I wish to make two additional points. Firstly, the changes set out in the schedule to the bill have already been approved by either Cabinet under Section 11 or by Finance Committee itself during 2023 under Section 12. Mr. Speaker, the schedule to the bill has a total of 124 appropriation changes recorded thereon. These changes were previously approved by Cabinet under the Act Section 11 and Finance Committee under Section 12. Mr. Speaker, the operating expenditure appropriation changes have a net total of $113.3 million, whilst the capital expenditure and investment changes total a net $9.1 million. I have used the word net because there are reductions to expenditures as well as the more numerous and dominant increases to expenditure. Mr. Speaker, a point worth repeating is that the items on the schedule to the bill have been previously approved by Finance Committee itself at meetings held in June and September 2023, and by Cabinet under Section 11, subsection 5, throughout 2023, and for which honorable ministers and honorable official members of Cabinet would have made statements in the House throughout 2023 that explained the need for granting approvals for such items. And secondly, Mr. Speaker, it is the government's reasonable expectation that given the circumstances explaining the origin of this supplementary appropriation bill, that it is a legal administrative exercise with respect to supplementary expenditures that have already been approved. It is our reasonable expectation that the Finance Committee process, which must follow the second reading of the bill, will also proceed accordingly. Mr. Speaker, this bill indicates changes that can be categorized as follows. Items on the schedule to the bill were where Cabinet has legally empowered to do so under Section 11.5 were made to the 2023 financial year budgets, and items on the schedule to the bill that Finance Committee itself approved in June and September 2023 under Section 12. Mr. Speaker, the significant appropriation changes included in the bill are $34 million, which reflects an increase in the budgeted healthcare costs with respect to indigents, seafarers, and veterans and their dependents. $16.6 million for land acquisitions, $14.9 million for local and overseas scholarships, $10.4 million for major roadworks and miscellaneous road surface upgrades, $9.3 million of additional costs for secondary education services as requested. $3.6 million is shown in the schedule to the bill for additional costs with respect to facilities maintenance and operational school support services. $3.5 million increase in output funding for education services, including primary and early education support services, mainly to address immediate spacing needs in government schools. $2.9 million for the acquisition of a third Twin Otter aircraft to accommodate the current and growing demand of additional flights to and from Little Cayman. $2.3 million to assist the Georgetown landfill remediation works, and $1.7 million for the completion of the Ponciana Rehabilitation Center. Mr. Speaker, the bill consists of three main parts. Clause 1 provides the proposed name of the proposed act. Clause 2 speaks to the appropriation authority of Cabinet. The schedule to the bill, which shows the individual items of appropriation changes that Parliament is being asked to approve. Mr. Speaker, since all of these items on the schedule to the bill have been previously approved by Cabinet and by Finance Committee itself, the matter now before the House is a legal administrative exercise to codify all of the previously approved changes to the 2023 budget into one document. The bill now before the House is now before the House, and I respectfully commend and ask all members of the House to support the bill. I'd like to thank the Ministry of Finance, particularly the leadership of the Financial Secretary, for the preparation of this bill. Thank you, Mr. Speaker.
Thank you, Honorable Acting Premier and Acting Minister of Finance. The bill has been duly moved. Does any member wish to speak? Does any member wish to speak? Final call. Does any member wish to speak? The Honorable Leader of the Opposition.
Thank you, Mr. Speaker. Mr. Speaker, just to say that we reserve any comments to the question time when we are in Finance Committee in dealing with the bill.
Thank you, Honorable Leader of the Opposition. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If no other member wishes to speak, I'll call upon the Honorable Acting Premier and Acting Minister of Finance to exercise his right of reply.
Thank you, Mr. Speaker. Much appreciated. I now commend the bill to the House.
The question is that a bill shortly entitled the Supplementary Appropriation January 2023 to December 2023 Bill 2024 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, the Supplementary Appropriation January 2023 to December 23 Bill 2024 has been given a second reading. Pursuant to Standing Order 67-1B, the bill now stands referred to Finance Committee. That concludes the second reading of the bills. The House will now resolve itself into committee for consideration of the bills. The House is now in committee. Please be seated. Good afternoon again. With the leave of the House, may I assume that as usual, we would authorize the Honorable Attorney General to correct minor errors and such the like in these bills? I shall take the absence of a response to be yes. Madam Clerk, would you please state the first bill and read the clauses?
Firearms Amendment Bill 2024, Clause 1, short title.
The question is that Clause 1, short title, do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 1, short title, stands part of the bill. To the title? You got to do the long title.
Clause 2, amendment of Section 2 of the Firearms Act 2008 revision, definitions and interpretation.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, thank you. In accordance with Standing Order 52.1 and 2, I, the Attorney General, give notice to move the following amendment to the Firearms Amendment Bill 2024, that the bill be amended in Clause 2 by deleting the word automatic SEER wherever it appears and substituting the words automatic conversion device.
Thank you, Honorable Attorney General. The question is? Yeah. The question is that the bill be amended in Clause 2 by removing the words automatic SARE and replacing them with the words automatic conversion device. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 2 is amended. Sorry, the question is that the clause 2 be amended accordingly. Those in favor, please say aye. Aye. Those against, no. The ayes have it. The clause 2 as amended stands part of the bill.
Mr. Speaker, I take the other amendments on Clause 2. Thank you. Yeah. Thank you. Mr. Speaker, thank you, Chair. I beg that the further amendments be done to Clause 2 in accordance with Standing Order 52(1) and 2, that the bill be amended in paragraph B in the definition of the word firearm as follows. 1, in paragraph A, by deleting subparagraph 3 and substituting the following subparagraph. Numeral 3, weapon under subparagraph 1 or 2 that is a privately made firearm created by the use of a 3D printer, a computer, numerical controlling milling machine, or similar computer system, and the use of electronic software, downloadable files, or similar computer data. And numeral 2, by deleting paragraphs 1 and 2, appearing after the words "but does not include," and substituting the following paragraphs. 1, an antique firearm. 2, a flare gun used for sending signals or carried as a necessary part of safety equipment in the course of navigation at sea, except where the flare gun is adapted to discharge ammunition. Or 3, a spear gun. And B, in paragraph D as follows, by deleting the definition of the words airsoft weapon. 2, by deleting the definition of the words prohibited ammunition and substituting the following definition. That is, prohibited ammunition means any A, projectile manufactured to be discharged from any artillery. B, incendiary type ammunition. C, armor piercing or similar ammunition. D, ammunition designed or adapted to contain or otherwise capable of containing a noxious liquid, gas, or things. E, ammunition that is designed to 1, to explode on impact, 2, to change its components on or before impact, except ammunition of .22 caliber or below. And F, other type of caliber of ammunition as may be prescribed. And 3, in the definition of the words prohibited device by deleting subparagraph B and substituting the following paragraph, B, reloader. And 4, in the definition of the words prohibited weapon by deleting the paragraph 1 and renumbering paragraph accordingly, renumbering accordingly. And B, by deleting the definition of the word 3D printed firearm and substituting the following definition. Quote, 3D printed firearm means a lethal barrel weapon which discharges or is designed to discharge a shot, bullet, or other projectile, and that is mostly manufactured by the use of a 3D printer, a computer numerical controlling milling machine, or similar computer system, and the use of electronic software downloadable files, or similar computer data. End of quote.
The amendment has been duly moved. Does any member wish to speak thereto? If no member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye. Aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 2 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 3, amendment of Section 3. Restriction on importation or exportation of firearms and a bulletproof vest.
Honorable Attorney General.
Thank you, Mr. Speaker. I move that the bill be amended in Clause 3 as follows. A, in paragraph C, in the new subsection 1B by deleting the words regarding possession and use and substituting the words regarding licenses, permits, possession, and use. And B, in paragraph D, in the new subsection 3C by deleting the words under subsection 3A, B, and substituting the words under subsection 3AA. Thank you.
The amendment has been duly moved. That is the amendment to Clause 3. Does any member wish to speak thereto? If no member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that Clause 3 as amended stand part of the bill. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 4, repeal and substitution of Section 4. Travelers to make declaration of firearms and bulletproof vest. Clause 5, repeal and substitution of Section 5, traveler's option. Clause 6, repeal and substitution of Section 6, custody of firearms and bulletproof vest by customs officer. Clause 7, amendment of Section 7, firearms and bulletproof vests not to be deemed to be imported into the islands in certain circumstances. Clause 8, amendment of Section 8, restrictions upon acquisition or disposal of firearms and bulletproof vest. Clause 9, amendment of Section 9, restrictions on delivery of firearms. Clause 10, insertion of new Section 9A, restrictions on acquisition to or more manufacturers of component parts.
The question is that clauses 4 to 10 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 4 to 10 stand part of the bill.
Clause 11, insertion of new Section 12A, restrictions relating to alteration or ballistic signature or conversion into firearm.
Honorable Attorney, there's an amendment to this clause.
Thank you, Mr. Chair, Mr. Speaker, sorry. Mr. Speaker.
Mr. Chair is fine, I'm in committee.
Sorry, thank you, Mr. Chair. Thank you, sir. I beg to move the amendment to Clause 11 as follows. In subsection 1, by deleting paragraph A and substituting the following paragraph. A, except where repairs are notified under subsection 2, do anything to a firearm that alters the ballistic signature of the firearm. And B, by inserting after the new subsection 1 the following subsection and renumbering accordingly. 2, prior to effecting repairs to a firearm, the Commissioner shall be notified of any A, repairs to be effected to the firearm, including any component parts that are to be replaced, and B, other details as may be required, and the notification and required details shall be provided in the form and manner as may be prescribed. I thank you.
The amendment to Clause 11 has been duly moved. Does any member wish to speak thereto? If no member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye. Aye. Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that Clause 11, as amended, stand part of the bill. Those in favor, please say aye. Aye. Those against, no. The ayes have it. Clause 11, as amended, stands part of the bill.
Clause 12, amendment of section 15, possession and use of firearms and bulletproof vests.
Clause 12. Thank you, Mr.
There's an amendment to Clause 12.
Thank you, Mr. Chair. Mr. Chair, I'd like to move amendment to Clause 12 as follows. In paragraph D, in the new subsection 4A, by inserting after the words a prohibited device, the following words, except where permitted by this act. And B, by deleting paragraph E and substituting the following paragraph. E, by repealing subsection 5 and substituting the following subsections. 5, bracket, subject to subsection 6 and 7, a person who contravenes A, subsection 1, commits an offense, and subject to section 39, is liable on conviction to a fine of $100,000 and to imprisonment for a term of 20 years or both, except that where the firearm is a prohibited weapon, persons liable on conviction to a penalty under paragraph D. B, subsection 3 commits an offense and is liable on conviction to a fine of $100,000 or to imprisonment for a term of 20 years, or to both. C, subsection 4A, commits an offense and is liable on conviction to a fine of $100,000 or to imprisonment for a term of 10 years, or to both. And D, subsection 4A-B, commits an offense and is liable on conviction to a fine of $250,000 or to imprisonment for a term of 35 years, or to both. 6, for the purposes of subsection 5C, an offense in relation to possession is not committed where the prohibited device is a specified prohibited device that is in the person's possession in accordance with an order under section 3(1)(b). And 7, where the contravention under subsection 4AA is in respect of a reloader, the person is liable on conviction to a fine of $100,000 or to imprisonment for a term of 20 years or to both. Thank you, sir.
The amendment to Clause 12 has been duly moved. Does any member wish to speak thereto? If no member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that Clause 12 as as amended stand part of the bill. Those in favor, please say aye. Those against, no. The ayes have it. Clause 12 as amended stands part of the bill.
Clause 13, insertion of new section 15A. Sorry. Prohibition on storing, sorry. Sorry. Clause 13, insertion of new section 15A, prohibition on storing or stockpiling prohibited weapons and prohibited ammunition.
Thank you, Mr. Chairman. Mr. Chair, sorry. Mr. Chair, I move in accordance with Standing Order 52.1 and 2 that clause 13, that it be amended by deleting clause 13. I'm sorry. That it be amended by deleting clause 13. That's all.
The question is that the bill be amended by deleting clause 13. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 13 is hereby deleted.
Clause 14, amendment to section 18, restrictions relating to the discharge and carriage of firearms and the wearing of bulletproof vests.
Thank you, Chair.
Yeah. There's an amendment.
Thank you, Mr. Chair. The bill be amended in clause 14 by deleting the words prohibited device wherever they appear and substituting the words prohibited weapon.
The amendment has been duly moved. Does any member wish to speak thereto? If no member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 14 as amended stand part of the bill. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 14 as amended stands part of the bill.
Clause 15, insertion of new section 18A, prohibition on manufacture or supply of firearm or ammunition.
Honorable Attorney General,
Thank you,
there's an
Mr.
amendment.
Chair. The bill be amended. I move that the bill be amended in clause 15 in the new section 18A by deleting subsections 1 and 2 and substituting the following subsections. 1, a person shall not assemble, manufacture, including create by the use of a 3D printer, a computer numerical control milling machine, or similar computer system, and the use of electronic software, downloadable files, or similar computer data, or supply any firearm, ammunition, or parts kit. A person shall not access, download, or have in the person's possession electronic software, downloadable files, or similar computer data that pertain to a firearm that are capable of being used with a 3D printer, a computer numerical control milling machine, or similar computer system with the intent to assemble, manufacture, or supply a firearm derived from the electronic software, downloadable files, or similar computer data. Thank you. Mr. Chair, this is important because I think, as I mentioned earlier during my debate, there was a misunderstanding that the government was attempting to criminalize the possession of 3D printers. What we're really after is a software that can be used by the 3D printers to assemble, to make a firearm, create a firearm. And what we have here is we insert the word with the intent to assemble, manufacture, or supply a firearm derived from the electronic software adjusting the computer data. Just to clarify. Thank you, sir.
Thank you, Honorable AG. The amendment has been duly moved. Does any member wish to speak thereto?
Mr. Chair.
Mr. Bryan? Minister Bryan?
Thank you, Mr. Chair. I think that it'd be a great opportunity for me to highlight the specific word in the amendment to the clause which speaks to the intent. I, like many members of the government, have received concerns about software that can be used in a double purpose, particularly those of engineers. There's a particular software called AutoCAD, whereby engineers use to help develop engineering plans, and this software, when used with a 3D printer, has the potential to build a gun, a device. And there was concerns that this program, with its commonality within the engineering community, whether they would be breaking the law to have it. Since speaking with our legal advisors as per the development of this piece of legislation, the key word is the intent. So you could have a software which has unlimitless potential, even that of printing a firearm, but the burden of proof would have to be on the person having software, also having a 3D printer, and also having the intention to create a firearm, not the mere fact of just simply owning the software. So, Mr. Chairman, I only highlight this to give comfort to those within the engineering community to know that this law will not prohibit you from having the necessary software that is currently being used within the industry called AutoCAD that helps developers produce many of our developing functions. Thank you, Mr. Chair.
Thank you, Minister Bryan. Minister Seymour?
Thank you, Mr. Chair. I'd like the honorable member to, for my edification, clarity and for the record.
Which honorable member?
Honorable AG, sorry.
Okay.
Terms of the clause, it is noted in the clause in terms of the penalty. A person who contravenes the provision is liable of conviction to a fine of $250,000 or to imprisonment for a term of 35 years or to both. I'm just trying to ascertain that this is up to.
Thank you, Mr. Chair. Thank you, Minister. So it is, yes, the amount is an outer limit. So it would be up to $1, from $1 up to the maximum amount, or from up to 1 day to 35 years. It's just a range. Thank you.
Does any other member wish to speak? If no member wishes to speak, the question is that clause 14 as amended stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clause 14 as amended stands part of the bill. No, it's 14.
No, 15, clause 14.
Oh my. I will start over. Honorable members, can we have a do-over there? I used the wrong clause number and it could be very confusing, especially with a bill that has such serious consequences in the event that people breach the act. So I'll start over again. The question is that the amendment stands part of clause 15. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. And the question now is that clause 15, as amended, stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause is amended, stands part of the bill.
Clause 16, amendment of section 19, types of licenses and permits. Clause 17, amendment of section 21, general provisions as to grant and issue of licenses and permits. Clause 18, insertion of new section 30A, collection and storage of ballistic signatures. Clause 19, amendment of section 35, search warrants.
The question is that clauses 16 to 19 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 16 to 19 stand part of the bill.
Clause 20, amendment of section 37, custody of firearms.
Thank you, Mr. Chair. That the bill be amended in clause 20 by deleting paragraph B and substituting the following paragraph. B in subsection 2 by repealing paragraph A and substituting the following paragraph. A, so the holder of a firearm uses restricted license in respect of a similar type of firearm in instances where the period of absence from the islands is 7 days or less. And Mr. Chair, the Honorable Deputy Leader of the Opposition had some observation about 7 days or less and was proposing during discussion that some consideration be given to changing the provision. I have conferred with the police, and they are not minded to, Mr. Speaker, but the member is free as usual. The honourable member is entitled to raise a matter on the floor. Thank you.
I should say the amendment has been duly moved. Does any member wish to speak thereto?
Thank you, Mr. Chairman. Mr. Chairman, there was a lot of discussion surrounding this this amendment, and I believe that whilst the Sports Shooting Association had advocated for the amendment as it stands, there were further concerns or further questions around a few things. One being, should there actually be a shorter period of time where if a licensed firearm holder is leaving a jurisdiction, let us say for just 2 nights. I think an example was used that perhaps members of the Sports Shooting Association attended an event overseas and 9 of them were going. That would be, and they were just going for 2 nights and a weekend, that would be 9 people showing up to relinquish their guns to the Commissioner of Police otherwise finding someone to hold the 9 guns. The question was asked, it's only if the license holder leaves the jurisdiction. So if the license holder does a staycation on an opposite side of the island, or in fact, perhaps on one of the other 3 islands, this doesn't apply to them. And if they do a weekend staycation, they have not left the jurisdiction, so it does not apply. And the question was, is it necessary for someone, considering that we have very, very high standards for the safekeeping of licensed firearms in the country, with annual inspections, very high standards of the safes that have to be used, everyone invests in alarms, etc. Is it necessary to have everyone find someone to hold their licensed firearm, or to turn in their licensed firearm if they are on a staycation? It doesn't apply to them because it says out of the jurisdiction, I think, traveling. Or if they travel for 2 days or 3 nights or 2 nights, were some of the concerns. I think, Mr. AG, the other question was, and just to clarify, that this only applies to the firearm and not the ammunition, or is ammunition included? So, Mr. Chairman, just for clarity, the amendments read that if you were leaving the jurisdiction, you had to turn in your firearm or firearms to the Commissioner of Police. The amendment before us now allows that permit holder to have someone with a similar license for the type of firearm to hold that firearm for them should they leave the jurisdiction for a period to 7 days or less. So outside of that, if you are leaving the jurisdiction, you have to turn in your firearm to the Commissioner of Police. And my second question on that is, does that include the ammunition or just the firearm?
Mr. Hugh, thank you for raising that point, but that raises a bigger point with me. Now, I know I'm the speaker and I don't really have a voice, but am I understanding what you are saying? Mean that anyone who holds a restricted license for a firearm, every time they leave Cayman, they have to take them and give them to the police? Forgive me for saying this, but this is absolute madness. Absolute madness. And the police do not have the capacity to deal with it. I know, I probably said too much already, but it's absolute madness. And it's going to result in nothing but chaos. And you're going to find, because I'm a holder of a restricted firearm license, which I've had in my possession for 20 odd years. It's been fine in the safe. Now I have to take it out of my safe to give it to a police officer who may leave it in the police car when he stopped to get coffee. It's madness.
Mr. Chair? Mr. Chair? Mr. Chair, I think it's important that we put a little bit of clarity to the proposed changes, though I agree with you wholeheartedly that it may be impractical.
Mr. Bryan, before you do, the AG is considering, I really would like his response, because this is a massive issue. I'm surprised nobody raised it in the debate.
Thank you, Mr. Speaker. Mr. Chair, sorry. As I said, the police position is that they prefer it to remain this way. However, they're not prepared, they're not dying in the ditch for it. But just to point out, for members' benefit, and I don't know if I should tell you that on the air, But if you look at the current legislation, it says you shall do so.
Honorable Attorney General, I don't know of anyone who does. And where would the police put these weapons? Well, we're going to give it currency now if we pass the bill in this form. I repeat again, and I know I'm stepping over the line. It's madness.
Mr. Speaker, and I think Minister Bryan wants to speak, but if it is that the members think it is more practical to change it, the police wouldn't be violently opposed to it. What they're really concerned about is that there's some safety and accountability when persons are traveling over the firearm.
But Honorable AG, I've just gone through the process of having my premises, my safe, everything inspected. The police took details of everything, including where the cameras are. So what we're risking now, in my view, is forcing firearm license holders to remove their firearms from a place which the police has approved as safe, to hand it to a police officer who, quite frankly, you don't know what can happen to it after that.
So, thank you, Mr.
And if you get many of these, because people will Cayman travel all the time, what are you going to do with them? They can give me Minister Bryan's gun when I go to get mine.
Mr. Chair, I think it's important for the record that everybody in this country knows I do not own a licensed or unlicensed firearm, just for the record. Thank you.
Sorry. But Mr. Chair, thank you, sir. The truth is that I think this provision was crafted at a time when the circumstances were different. You just mentioned about your premises being hardened, and I don't think that's the case for most firearm holders now. Their premises have been hardened, and they have surveillance equipment, irrespective of where in the world they are. They can monitor their premises and so. So, as I said again, it is a committee stage amendment, and if it is that members feel very strongly about it, then clearly it's something that I think the government can live with, given the police's position on it. But they weren't prepared to die in the ditch for it.
Mr. Honorable AG and members, I've already stepped over the line. I better not say any more. It's really in the hands of the committee to decide what you wish to do. But I don't think anyone is now in doubt of what I think about it.
Mr. Chair.
Mr. Chair, through you, sir, and just to say, I mean, I am not a licensed firearm. I do not own a firearm, but this I see as problematic because a couple of questions there. I think there's a huge concern there, and we brought the examples made. It is very possible that the persons from the Sports Shooting Association one weekend decide to travel together, 6, 7, 8, 9, 10, a dozen of them. That is going to be problematic. The movement of the guns just for 2 nights, and as I said, the practical side of it for me is that if you live in Grand Cayman and you go to the Sister Islands for 2 weeks, it doesn't matter because you haven't left the jurisdiction. And if your alarm is to go to 911, it doesn't matter if you are in Grand Cayman or not, your alarm is still going to go to your security company or to 911. Or if you get it on your phone, you can still call the police as ably as you can if you in Cayman or overseas. It just, in that sense, doesn't make a whole lot of sense to me. There were a lot of others who raised concerns. I didn't raise it. I did raise it during my debate, but I did say that we had quite a bit of discussion, and the AG had undertaken to go and speak with the commissioner on the matter. But there were many others in the group who were, in fact, licensed or permitted firearm owners that had real issues with it as well. So I just think again, I know the process. I know how difficult it is to get your place passed, to pass inspections that are needed for you to store and own your firearm. Is it necessary that every time you leave the country, you have to either have a friend with a similar license hold your gun? And I said in the meeting, I haven't met that friend yet that I would leave my firearm with him or her, or hand it in to the commissioner.
The Honorable Acting, supposed to call you by name, Minister Ebanks, Deputy Premier Ebanks.
Thank you, Mr. Chair. As the Deputy Leader of the Opposition mentioned, when we were in suspension and we were in the committee room yesterday, this point was raised, and we acknowledged the historical, probably hangover of the existing legislation, and we discussed this at length. What I propose, Mr. Chair, is that we just take a 5-minute recess, if you would allow, so that the Attorney General can meet with his team to propose an amendment, and we deal with this today.
I think that the suggestion of a suspension is a very good one, but 5 minutes is never proven to be enough. So shall we try to resume at 6?
Yes, sir.
The committee suspend until 6 o'clock.
Thank you, Mr. Chair.
Good evening. Committee is resumed. I just want to say that we should take parliamentary notice that a 5-minute suspension is actually 60 minutes long. Madam Clerk. Honorable Mr. Bulgin.
Thank you. Thank you, Mr. Chair. So, Madam Clerk, I am guided by you. So, we were debating paragraph 8 of the existing committee stage amendment, which is clause 20. With this new replacement, do I formally apply to withdraw paragraph 8? Thank you very much. Thank you. Thank you very much. So, Mr. Chair, with your leave, I move a motion to withdraw paragraph 8 of the existing committee stage amendment and to substitute, therefore, the one-page amendment that has been circulated to honorable members as it relates to clause 20.
The motion has been moved. Those in favor of the withdrawal of the current paragraph 8 of the committee stage amendments relating to the Firearms Act Amendment Bill and the replacement with the wording that has just been circulated, please say aye.
Aye.
Those against, no. The ayes have it. Paragraph 8 of the original Notice of Committee Stage Amendment number 2 is withdrawn, and substituted, therefore, is Committee Stage Amendment number 3, which has recently been circulated to members.
So read number 3.
Mr. Bulgin, we need you to essentially move the number 3 amendment. Yes.
Thank you, Mr. Chair. So, Mr. Chair, in accordance with Provisional Standing Order 52(1) and 2, I, Honorable Attorney General, do move the following notice of further amendments to the Firearms Amendment Bill 2023 as pursuant to, as circulated in Notice of Amendment, Notice of Committee Stage Amendment number 3. And the amendment reads, sir, 1, that the bill be amended in clause 20 by deleting paragraph B and substituting the following paragraph. B, by repealing subsection 2 and substituting the following subsection. Number 2, where any holder of any firearm uses restricted license is about to leave the island for 21 days or more and does not desire to take the firearm and ammunition to which such license relates, the holder shall, before leaving the island, deliver the firearm and the ammunition to the officer in charge of a police station. And thank you.
The amendment has been duly moved. Does any member wish to speak thereto? If no member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 20 as amended stand part of the bill. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 21, amendment of section 39, minimum sentences for certain offenses.
Thank you, Mr. Mr. Chair. Clause 21, going back to the old document.
Honorable AG, there is an amendment to clause 21.
Thank you, Mr. Chair. Mr. Chair, in accordance with Standing Order 52.1 and 2, I move the following amendment to clause 21. Amendment of section 39, minimum sentences for certain offenses. 21, the principal act is amended in section 39 as follows.
Excuse me, Mr. Bulgin. I believe you need to start with paragraph 9, because we're deleting clause 21.
Yes, thanks. Yeah. I read, sorry, that the bill be amended by deleting clause 21 and substituting the following clause. Amendment of section 39, minimum sentences for certain offenses. Thank you, Mr. Chair. Principal act is amended in section 39 as follows. A, in subsection 1 as follows. Numeral 1, in paragraph A, by deleting the words under section 33.15.5 and substituting the words under section 3333A, B, 15.5A, 15.5C, and 2, by deleting paragraph C and substituting the following paragraph. C, the offense in respect of a firearm or a prohibited weapon, and B, in subsection 2 as follows. In paragraph A, by deleting the words at least 7 years and substituting the words at least 10 years. And 2, in paragraph B, by deleting the words at least 10 years and substituting the words at least 15 years.
The amendment has been duly moved. Does any member wish to speak thereto? If no member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye. Aye. Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 21 as amended stand part of the bill. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause is amended, stands part of the bill.
Clause 22, repeal and substitution of section 40, restriction on eligibility for release on license.
There's an amendment. Honorable AG.
Thank you, Mr. Chair. Mr. Chair, in accordance with Standing Order 52.1 and 2, I move the following amendment, that the bill be amended in clause 22 in the new section 40 as follows. A, by deleting paragraph B and substituting the following paragraph. B, contravenes section 3.1A, B, and is convicted and sentenced under sections 3A, B, and B, by deleting paragraph C and substituting the following paragraph. C, contravenes section 15.1 and is convicted and sentenced under section 15.5A or. Thank you, sir.
The motion has been duly moved. The amendment has been duly moved. Does any member wish to speak thereto? If no member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 22 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 23, amendment of section 41, forfeiture of firearms.
Honorable AG, there's an amendment.
Thank you, Mr. Chair. I beg to move the amendment. So in accordance with Standing Order 52.1 and 2, that the bill be amended in Clause 23 by deleting paragraph D and renumbering accordingly.
Amendment has been duly moved. Does any member wish to speak thereto? If no member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 23 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 24.
Clause 24, amendment of section 44, when provisions shall not apply.
Thank you. Sorry.
I don't have that one.
So one page. At the regiment. Thank you, Mr. Chair. In accordance with Standing Order 52.1 and 2, I, Honorable Attorney General, move the following amendment, that the bill be amended in Clause 24C in the new Section 44D by inserting after subparagraph 3 the following subparagraph and renumbering accordingly. Numeral 4, Cayman Islands Regiment.
The amendment has been duly moved. Does any member wish to speak thereto? If no member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 24, as amended, stands part of the bill. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 25, transitional.
The question is that clause 25 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 25 stands part of the bill.
A bill for an act to amend the Firearms Act, 2008 revision, to amend the definition of firearm, to provide definitions for, among other words, privately made firearm, prohibited device, and prohibited weapon, to provide for offenses relating to, among other things, the importation of prohibited devices and prohibited weapons, to provide for the ban on the manufacture of firearms and the altercation or conversion of firearms, to empower the Commissioner to collect ballistic signatures and information relating to firearms in the islands, and for incidental and connected purposes.
The question is that the long title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The long title stands part of the bill.
Summary Jurisdiction Amendment Bill 2024. Clause 1, short title. Clause 2, Amendment of Section 7 of the Summary Jurisdiction Act 2024 revision, appointment of justices of the peace. Clause 3, repeal and substitution of Section 8, removal of justices of the peace. Clause 4, repeal and substitution of Section 43D, retention of appointment. Clause 5, previous exercise of duties by justices of the peace not affected. Clause 6, transitional provisions.
The question is that clauses 1 to 6 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 to 6 stand part of the bill.
A bill for an act to amend the Summary Jurisdiction Act 2024 revision to provide for the appointment of members of Parliament as justices of the peace. Virtue officii, to restrict members of Parliament from exercising certain powers, functions, or duties of the justices of the peace to avoid conflict with their roles as members of Parliament and for incidental and connected purposes.
The question is that the long title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The long title stands part of the bill.
Perpetuities Amendment Bill 2024. Clause 1, short title. Clause 2, insertion of new part heading in the Perpetuities Act 1999 revision, preliminary rule against perpetuities. Clause 3, amendment of Section 4, rule against perpetuities. Clause 4, amendment of Section 14, reformation. Clause 5, amendment of Section 15, application to the court. Clause 6, insertion of new Part 3, the disapplication of the rule against perpetuities.
The question is that clauses 1 to 6 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 to 6 stand part of the bill.
A bill for an act to amend the Perpetuities Act 1999 revision to provide for the disapplication of the rule against perpetuities, to correct typographical errors, and for incidental and connected purposes.
The question is that the long title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The long title stands part of the bill.
Pharmacy Bill 2024. Clause 1, short title and commencement. Clause 2, interpretation. Clause 3, importing medicines. Clause 4, manufacturing license. Clause 5, wholesale license. Clause 6, dispensing license. Clause 7, application for license. Clause 8, criteria for issuing license. Clause 9, decision on license application. Clause 10, duration and conditions of license. Clause 11, variation, suspension, and revocation of license. Clause 12, medicine approval. Clause 13, exceptional use authorization. Clause 14, emergency use authorization.
The question is that clauses 1 through 14 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 14 stand part of the bill.
Clause 15, dealing with non-approved medicine. Clause 16, supplying a medicine. Clause 17, compounding a medicine. Clause 18, altering a medicine. Clause 19, labeling of medicine. Clause 20, information accompanying medicine. Clause 21, vending machines. Clause 22, internet and mail order pharmacies. Clause 23, wholesale of pharmacy or prescription only medicine. Clause 24, prescribing medicine. Clause 25, altering a prescription. Clause 26, dispensing a prescription only medicine. Clause 27, interchangeable and bioequivalent generic medicines. Clause 28, dispensing samples. Clause 29, administering a prescription-only medicine. Clause 30, possessing a prescription-only medicine. Supply and labeling of poison. Sorry, I said what? I said nothing?
Okay, I got it.
Sorry. Clause 31, supply and labeling of poison.
The question is that clauses 15 through 31 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 15 through 31 stand part of the bill.
Clause 32, appointment of inspectors. Clause 33, powers of inspectors. Clause 34, restrictions on powers of entry. Clause 35, dealing with seized items. Clause 36, obstructing an inspector. Clause 37, approval forms. Clause 37, approved forms. Clause 38, protection from liability and indemnity. Clause 39, confidentiality of information. Clause 40, appeals. Clause 41, regulations. Clause 42, repeals.
The question is that clauses 32 through 42 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 32 through 42 stand part of the bill.
A bill for an act to repeal and replace the Pharmacy Act 1979 and the Pharmacy Act 1991 to regulate the importation, manufacture, wholesale, dispensing, and prescribing of medicines and for incidental and connected purposes.
The question is that the long title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The long title stands part of the bill. Honorable members, that brings to a conclusion the consideration of the bills in committee. The question now is that the bills be duly reported to the House. Those in favor, please say aye. Aye. Those against, no. The ayes have it. The bills will be reported to the House. The House will now resume.
Report on bills. Firearm Amendment Bill 2024.
The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to report that the bill entitled the Firearms Amendment Bill 2024 has been considered by a committee of the whole House and passed with several amendments.
Madam Clerk. The bill has been duly reported and is set down for third reading.
Summary Jurisdiction Amendment Bill 2024.
The Honorable Acting Deputy Governor.
Thank you, Mr. Speaker. I am pleased to report that a bill shortly entitled the Summary Jurisdiction Amendment Bill 2024, which has been considered by Committee of the whole House and passed without amendment.
The bill has been duly reported and is set down for third reading.
Perpetuities Amendment Bill 2024.
The Honorable Acting Premier.
Thank you, Mr. Speaker. I'm pleased to report that a bill shortly entitled the Perpetuities Amendment Bill 2024 was considered by a committee of the whole House and passed without amendments.
The bill has been duly reported and is set down for third reading.
Pharmacist Bill 2024.
The Honorable Minister of Health and Wellness.
Thank you, Mr. Speaker. Mr. Speaker, I am to report that a committee of the whole House has considered the bill shortly entitled Pharmacy Bill 2024, and it was passed without amendments.
The bill has been duly reported and is set down for third reading.
Third readings. Firearm Amendment Bill 2024.
One moment, please, Honorable Lady. Madam Clerk, remind me, the first readings of these were done yesterday? Okay, fine. Please proceed, Honorable Lady. Yeah.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill entitled the Firearms Amendment Bill 2024 be given a third reading and passed.
The question is that a bill shortly entitled Firearms Amendment Bill 2024 be given a third reading and passed. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Firearms Amendment Bill 2024 is duly passed.
Summary Jurisdiction Amendment Bill 2024.
The Honorable Acting Deputy Governor.
Thank you, Mr. Speaker. I beg to move that a bill shortly entitled the Summary Jurisdiction Amendment Bill 2024 be given a third reading and passed.
The question is that a bill shortly entitled the Summary Jurisdiction Amendment Bill 2024 be given a third reading and passed. Those in favor, please say aye.
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 Those against, no. The ayes have it. The Summary Jurisdiction Amendment Bill 2024 is duly passed.
Perpetuities Amendment Bill 2024.
The Honorable Acting Premier.
Thank you, Mr. Speaker. I beg to move that a bill shortly entitled the Perpetuities Amendment Bill 2024 be given a third reading and passed.
The question is that a bill shortly entitled Perpetuities Amendment Bill 2024 be given a third reading and passed. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Perpetuities Amendment Bill 2024 is duly passed.
Pharmacy Bill 2024.
The Honorable Minister of Health and Wellness.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the bill shortly entitled the Pharmacy Bill 2024 be read a third time and passed.
The question is that a bill shortly entitled Pharmacy Bill 2024 be given a third reading and passed. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Pharmacy Bill 2024 is duly passed.
Motions. Government Motion Number 7 of 2023-2024. Amendment to the Development Plan 1997. Proposed rezoning Block 23B, Parcel 108, 109, 110, and 111, Georgetown South, and relocation of public open space, to be moved by the Honorable Minister of Planning, Agriculture, Housing, Infrastructure, Transport, and Development.
I recognize the Honorable Minister for Planning, Agriculture, Housing, Infrastructure, Transport, and Development to move Government Motion Number 7 of 2023-2024.
Thank you, Mr. Speaker. Government Motion Number 7, 2023-2024, Amendment to the Development Plan 1997, proposed rezoning of Block 23B, Parcel 108, 109, 110, and 111, Georgetown South, and relocation of a public open space, whereas on the 10th of May, 2023, reference to the CPA on 11 of 23, item 3.1, the Central Planning Authority originally considered the request to amend the development plan from low-density residential to beach resort residential over Block 23B, Parcel 108, 109, 110, and 111. It was resolved to forward the proposed for a 60-day public notification and consultation period pursuant to Section 11.2 of the Development Planning Act 2021 revision. And whereas the proposed amendments were duly advertised in the Caymanian Times newspaper on the 31st of May and the 2nd, 7th, and the 9th of May, and of June 2023, in accordance to the Section 11.2 of the Development and Planning Act 21 revision, the public consultation closing on August the 8th of 2023, person was invited to view the application at the Department of Planning for comments. During the public consultation period, no letters or objections were received on the proposed amendments, and whereas on the 8th of November 2023, the CPA 2623 item 3.2 of the Central Planning Authority again considered and proposed, and in light receiving no objections, it was resolved to forward the rezone application to the Ministry of Planning, Agriculture, Housing, Infrastructure for onward transmission to the House of Parliament, subject to Cabinet's approval. And whereas on the 28th of May 2024, Cabinet considered the rezoning application and approved the matter to be referred to the Parliament for consideration. Be it now therefore resolved.
Honourable Minister. I have just read this, this motion carefully. I believe that the paragraph that you are about to read now is in fact not a resolution, but a recital, because the Parliament can't resolve what is provided there. So if you would simply read it as whereas in accordance with section 10.3, because the Parliament cannot resolve something that another agency is doing, in this case the Central Planning Authority. So instead of reading it, be it now therefore resolved, read it as whereas in accordance with, and then it's all fine. The only resolution for this Parliament is the last one.
Whereas in accordance with section 10.2b of the Development and Planning Act 2021 revision, the Central Planning Authority hereby recommends and submits to the Parliament the following proposal for the alteration of the Development Plan 1997, a summary and the maps of which are attached hereto, and be it further.
No.
Oh, sorry.
And be it resolved.
And be resolved, sorry. And to alter the zoning area of the registration of section Georgetown South, Block 23B, parcel 108, 109, 110, and 111 from low-density residential to beach resort residential, and to relocate the area zoned public open space to the western boundary of the property.
The motion is duly moved. Does the Honourable Minister wish to speak thereto?
Yes, sir. Mr. Speaker, and honourable members, I rise to present to you the motion to rezone the specific parcels of land in Georgetown South registration section to bring the zoning in line with the current land use and better facilitate future development plans. The area in question pertains to Block 23B, parcel 108, 109, 110, and 111. These parcels straddle different zoning classifications due to the realignment of the South Sound Road, resulting in a confusing and an inefficient zoning map. Specifically, the area has multiple zones, including a beach resort residential, a low-density residential, and a redundant road designation. Additionally, there is a section labeled public open space that lacks the accessibility and the connectivity due to the realignment of the South Sound Road many years ago. Area of the parcels originally designed as separate zones should have been unified, and there was also a portion of the land still designated as road, even though it was decommissioned following the road realignment. Additionally, the current public open space is not accessible without trespassing over private lands. So the Central Planning Authority considered the application to rezone the specific parcels on May 10th of 2023. The proposal was forwarded for a 60-day public notification and consultation period as May the 31st, June the 2nd, June the 7th, June the 9th of 2023. The consultation period concluded on the 8th of 2023 with no objections received. The results, Mr. Speaker, are that the parcels are consisting of zoning through and relocated public open space that along the adjacent easement, the public can now utilize the access and enjoy the coast. Mr. Speaker, honourable members, I move the Parliament resolve, I'm not going to use that word resolve, sorry, that we rezone the low-density residential parcel within Block 23B and parcel 108, 109, and 110 and 111 to beach resort residential, and remove the redundant road zoning from the subject land parcel and replace it with beach resort residential. And 3, relocate the public open space on Block 23B, parcel 108, to the western boundary of the property, ensuring it connects with the existing right-of-ways and the road. Honorable members, I urge you for your support on this motion, and I thank my colleagues for their full support. Thank you.
Thank you, Honorable Minister. Does any member wish to speak? The Honorable Leader of the Opposition.
Thank you, Mr. Speaker. Just to seek a little bit of clarity here, through you to the Minister. Minister, this looks like it's at the intersection of Old Crew Road and South Sound Road, am I correct? Yeah, so Old Crew Road. Okay. I'm okay knowing that, because I do believe that there are plans for development there. Yeah, okay.
Thank you. Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If no member wishes to speak, I shall invite the Honourable Minister to exercise his right of reply.
Mr. Speaker, I just want to thank the honourable members and my colleagues for their full support for this motion. The amendment to the development plan motion, Block 23B, 108, 109, 110, and 111 for Georgetown South, and relocation of the open public space.
Thank you. The question is, be it resolved to alter the zoning area of registration section, Georgetown South, Block 23B, parcels 108, 109, 110, and 111 from low density residential to beach resort residential, and to relocate an area zoned public open space to the western boundary of the property. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The motion is passed. Madam Clerk.
Government motion number 8 of 2023-2024, Public Management and Finance Law 2020 revision, issuance of a deed of indemnity to the members of the Planning Appeal Tribunal, to be moved by the Honourable Minister of Planning, Agriculture, Housing, Infrastructure, Transport and Development.
Honourable Minister of Planning, Agriculture, Housing, Infrastructure, Transport and Development. To move government motion number 8 of 2023-2024.
Thank you, Mr. Speaker. Public Management and Finance, government motion number 8 of the Public Management and Finance Law 2021 revision, issuance of a deed of indemnity to the members of Planning Appeals Tribunal, whereas the government of the Cayman Islands, the government is issuing a deed of indemnity to the members of the Public Appeals Tribunal as per attached the deed of indemnity, and whereas Section 8 of the Public Management Finance Law 2020 revision provides that a general rule of no guarantee may be given by on behalf of the government unless it has been authorized by a resolution of the Parliament. Be it now therefore resolved that the Parliament hereby authorize the issuance of the members of the Planning Appeals Tribunal of a deed of indemnity, guarding against the potential liability of members of the Planning Appeals Tribunal.
The motion has been duly moved. Does the honourable member wish to speak thereto?
Yes, sir. Mr. Speaker, I stand before the Honourable House today as the Minister of Planning, Agriculture, Housing, Infrastructure, Transport and Development to present government motion seeking the issue of a deed of indemnity to the members of the Planning Appeals Tribunal. Mr. Speaker, my ministry has observed that qualified and experienced individuals are increasingly hesitant to serve as directors of corporations and members of board. This is reluctant and is due to the growing risk of litigation costs and associated with their role and responsibilities unless they are protected by the comprehensive liability insurance or identification. Mr. Speaker, given the situation that the Ministry of PI and the T aims to issue this deed of indemnity, the members of the Planning Appeals Tribunal, this move is necessary to ensure that we can attract and retain the competent individuals to these important roles. Mr. Speaker, as required by Section 8 of the Public Management and Finance Act revision, we must obtain a resolution from Parliament to grant an approval to the deed of indemnity and a document along with the government motion. Mr. Speaker, was prepared by the Ministry and consultation with the legal department, and it has been approved as shown in. Mr. Speaker, there's a precedent for this similar of indemnity, that has been extended to civil servants in the past. And in closing, Mr. Speaker, I ask that support for this from the Honourable House to approve the issuance of this deed of indemnity to the members of the Planning Appeals Tribunal. Thank you.
Thank you, Honourable Minister. Does any member wish to speak? Does any member wish to speak? Does any member wish to speak? If no member wishes to speak, I'll invite the Honourable Minister to wind up.
Thank you, Mr. Speaker. I just want to thank my colleagues and this Honourable House and everyone in here for their tacit support, sir.
Thank you. The question is, be it now therefore resolved that the Parliament hereby authorizes the issuance to members of the Planning Appeals Tribunal of a deed of indemnity guarding against the potential liability of members of the Planning Appeals Tribunal. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The motion is passed. Honourable members, we have reached the end of the business on today's order paper, and thus I would invite the Honourable Acting Premier to move the motion of adjournment until 10 a.m. tomorrow morning. I understand that the government intends to, immediately following the resumption of Parliament, to go into Finance Committee to deal with the bill, the Supplementary Appropriation Bill, 2022-2023 bill, which was given a second reading earlier today. Following that, I don't expect that will last very long. I propose to begin private members' motions if there are parliamentary questions and so forth that are going to be asked or answered, I should say. We will deal with those before we go into Finance Committee. And then we can go into private members' motions, and hopefully we'll be able to finish the private members' motions certainly by the end of Thursday, I would expect. Honourable Acting Premier.
Thank you, Mr. Speaker. I'd like to thank all members of this House for all of the collaboration and work today. Just a second, Mr. Speaker. Excuse me, Mr. Speaker. As I was saying, thank you to all members of this honorable House for all of the work that we completed today to conclude all of the business on the order paper. With respect to Finance Committee, I just need to double check the timing with the Financial Secretary and his staff, and I'll confirm in the morning to all members of when we can place Finance Committee. But in the meantime, I'd like to, going on to 7:30, move to, that this House do adjourn this evening, and we resume Parliament proceedings tomorrow at 10 a.m.
Thank you. The question is that this House do now adjourn until 10 a.m. tomorrow morning. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The House is accordingly adjourned until 10 a.m. tomorrow morning.